Let's side any mentioning.
May I permit to mention a contempt matter, let it be included. A contempt matter, let it be included.
Contempt matter arising out of which order?
The writ petition, my lord.
Which is the order?
Before the vacation bench, my lord just passed an order, but same has been valid. For the vacation, I moved the before the my lord.
Where is the order? Where is the copy of the order?
Copy of the just I have not annexed. But
Come tomorrow. Come tomorrow.
My lord, I am
The order,
ministering
yes.
most humbly, my lord, I am ministering one matter. This matter was taken up by your lordships on Friday. My lord, regarding partial demolition, my lord, your lordship has appointed one commissioner advocate. And initially, your lordship, my lord, given the remuneration, rupees 5,000. Thereafter, my lord, learned lawyer of the corporation insisted your lordships to increase it as a 20,000, my lord. I on that very date, my lord, my client was not present before this court. My lord, I have communicated this my client, my lord, but they are, my lord, kindly, in place of 20,000, kindly reduce some amount, my lord. I shall give the notice to them. In place of 20,000, completely, my lord, kindly reduce because they will not be able to bear.
Give a notice and then mention.
I will give the
Not shall. Do it today only.
Today.
Bring your friend.
Yes.
Yes. Get them and come back.
My lord, may I be permitted to mention, my lord, 14 old motions which are taken up analogously by the Honorable Justice Shubhra Ghosh, and his lordship then was taken up the determination of land matter. But these are all 2017. All were taken analogously, my lord. 14.
Who is for the state?
My lord, it is the Union of India. My lord. They
Union?
are the main party. My
Who appeared for union?
lord. That I am mentioning. My lord.
You're there?
Details আছে না স্যার
Okay, you can notice. Without notice, why to mention? Notice ছাড়া আর নেব না এবার mentioning. Give a notice and then mention tomorrow. বুঝছো?
Item number 1.
For the state response.
The writ petition is dismissed. এটা চেম্বারে পাঠিয়ে দিন। Yes.
Item number 2.
Lord, I appear for
Item number 2 and 3.
when see both. Lord, I appear for the case.
Appearing together, item number 2 and item number 3. Lord, in WPA number 21387.
Yes.
Lord, I am the private. Lord, I have taken out an application for addition of party. And my lord, in WPA number and my lord, in WPA number 20903, my lord, I am the writ petition. In 21387, my lord, I am not there. I have taken out an application for being added as a part aspect. But before my lord looks to the brief, my lord, I just give your lordship the background. Spirit very short of letter. This is with regard to a particular plot of land. That number 2357 at Rajwa, which has been acquired. My lord, my writ petition is, my lord, for compensation. I say that, my lord, it was my land. It was, my lord, not inherited. My father gifted me. Land was acquired for some purpose by the state authorities. I was not given compensation. That is what is, my lord, my writ petition 20903 is all about. 21387 in, my lord, in which I have taken out an application for addition of party. The writ petition there is also, my lord, asking for compensation for the same acquisition for the same land. So, my lord, I become, my lord, a necessary.
Yes.
That's, my lord, my application can too taken out, my lord, in WPA number 21387.
I have filed an application. I have filed an affidavit in opposition to his application for addition of party.
My lord, that is mostly on merits. The opposition is mostly on merits that, my lord, I am not entitled and all. Those are, my lord, to be decided, my lord, once I, my lord,
Substitution application. One application substitution is there, my application, my lord. There are initially, there are three petitions, mother, son and daughter. Mother died.
Which one?
But can one.
21387, my lord, can one.
21387.
Here, my lord, can one. Three date petitioners, while arrangement was appearing, mother has died, son and daughter are
So both the
already-
applications pertains to 2-1, one for addition of party, one for substitution. Yeah. Executed 20. Now, the substitution is also to be made in 20903.
No, because he is possibly not there, my lord, in the added.
Petition only.
My lord, I'll just check, I'll just.
Or whether they are to be added as a party in the other repetition.
I think they should.
I have.
I think they should.
They have not-
As an officer of the court, my lord, I think they should. But my lord, he has not taken out an application yet. My lord, if my lord is so, my lord is.
So what I do is,
I have the submission, I have not to be added as party in
Oh,
his
great.
petition because it's my independent petition I have filed. And in my application petition, he has filed an application for addition of party, which I have opposed by.
now since they are substituted in the subsequent one, in his writ petition, you have sought for substitution
In my petition.
in your writ petition.
My
Oh.
petition.
It's rate petition number 3. That
21387,
Is
he has
my
sought for
added, right?
substitution. Okay. Awesome. Can 1 of 2022. This is an application for recording the date of petition number 1, Gauri Kaur Chaudhary. Which paragraph the legal yes, name of the legal yes are given? In which paragraph the names of the legal yes are given? Or is it just a simplicity and recording the name, date? There is no prayer for substitution. Reason state there is a petition is only success. Only recording the date, no substitution. The other legal years are already on record. So there is no question of substitution in recording the date. Huh? Mr. So-and-so, learned advocate for the applicants, submits that during the pendency of the writ petition, writ petitioner number 1, Gauri Kaur Chaudhary, has expired on 29th November 2021. Stop, as the other legal years are already on record as writ petitions number 2 and 3. The factum of death of petition number 1 be recorded in the writ petition. None opposes such prayer. Let the death of, on perusal of the death certificate annexed to the application, it is found that Gauri Kaur Chaudhary, petition number 1, expired on 29th November 2021. Considering the above, let the date of petition number 1, Gauri Kaur Chaudhary, be recorded in the cause title of the writ petition and her name be deleted therefrom. The application being Can 1 of 2022 stands disposed of. Can 2 of 2023, this is an application for addition of party. এগুলো সব ক্যান করবেন, ইন রিট পিটিশন নাম্বারটা দেবেন, দুটো অ্যানালগাস আছে। হ্যাঁ, মিস্টার সিদ্ধার্থ ব্যানার্জি, learned advocate appearing for the applicants, submits.
I have opposed the prayer, filing opposition. Let him file reply, let me justify.
You will not be filing any reply.
I have, because I have annexed those documents, which are very much relevant.
We'll decide all these matters. কি বললাম? Submits that the applicants have sought for compensation in respect of plot of land comprised using DAG number 2753, Putian 1072, Mouja Kosba, jail 13, Toji 145, under police station Kosba. In writ petition number WPA 20903 of 2019. The writ petition of the applicant, sorry, কেটে দিন. The petitioner herein has filed the present writ petition claiming for compensation in respect of the self-same property. As such, the applicants are necessary party in the present writ petition. Mr. So-and-so, learned advocate, for
I have two prayers.
petitioner opposing such prayer submits that the applicants do not have any interest in the property which has been acquired. Yes.
I have two prayers, because the initial direction of the government was to return the land to my place. That was the direction. I said not to the exemplar because for returning the land and in default, enter company.
So we are not, right now, we are not dealing with the merit of the applicant. Right?
But we are according to the submissions, in question the writ petition. These are the two prayers in the writ petition.
For compensation and return of land. কি বললাম? The petitioner has prayed for compensation as well as return of the land acquired. In the alternative, return of the land to the petitioners. Upon going through the averments made in the application as well as hearing the taking into consider the submissions advanced on behalf of the applicants, it is found that the applicants have also contended that they are the absolute owner in respect of the land acquired. Thus, they are necessary party. Accordingly, let the applicants be added as the party respondent in the writ petition being WPA 21387 of 2019. Department is directed to carry out necessary incorporation in the cause title of the writ petition. Petitioner is directed to serve amended copy of the writ petition upon the added respondents. Added respondent number. What will be your number in the writ petition? Added respondent number. So is directed to file affidavit in opposition within which time? Within a period of 3 weeks. A reply thereto, if any, be filed within a period of 1 week. Release this matter after কি এতে দিয়ে দেবো? January, monthly list.
Would it be my lord's kind visible to indicate a particular date? Of course, subject to my lord's kind convenience. Subject to my lord's kind.
After these affidavits are exchanged, let it be in the monthly list. You mention, then I put it in the hearing list. You mean monthly list, huh? Okay. We see.
I get the point of the state.
Utilize the vacation to find out the answer.
Annex those documents which are relevant
Wait
to
a
the
minute, sir.
operations bylaw. In support of my title, I have some,
Ajay, opposition you have filed today?
yes, ma'am.
Take to note করে নিন।
Representing the state, I am representing.
KMDA.
State.
Item number 4.
Applicant in the contempt
I
application.
make you appear on behalf of the alleged
What
contempt.
happened?
The last occasion, your lordship's pleasure was that Lord, I should start with Lord, the learned Lord, government leader as well as the learned advocate who represent Lord, the state while Lord, main petition was being disposed of. But it's my duty to point out before your lordship, the learned advocate did not accept that notice, my lord, since now my learned friend is appearing. Lord, he said Lord, thereafter the brief has not been allotted.
Yes, so what is the stage?
You will find from page 8, the order starts. Order is dated 29th of April 2024.
Huh.
Page 29, my lord, will find the encroaches can be divided largely on two
Yes.
blocks. One my lord come under the Ideas Act of my lord, and the other comes under the 1962 Act, Removal of Unauthorized Occupant Act. But this order was communicated to the Constitutional Bench on 4th of September 2024.
Right.
Where so far as the Ideas Act is concerned, on 20th August 2024, proceedings final order under the 10-3 orders have been passed. Next 20th August 2024, 10-3 orders have been passed. Now the appeal has been carried out, came for 32 I think before the district magistrate. So the district magistrate has heard the appeal on 2 occasions. Thereafter, we have tried to pay on behalf of appearance before the appellate forum, saying that the MAT application is pending before this honorable court against the impugned order. To which the appellate authority has deemed it feasible to grant 2 weeks of adjournment for the applicants to get stay order, if any, will, and the matter has been fixed on 16th of December 2024.
Okay.
This pillar in respect of the Ideas Act and 1962 Act, the order was lately communicated to the district magistrate. He has taken up the call. He has directed the
Okay, sir. What you do is you come up with all these details, file a comprehensive report on the next week. Let them have a look to the what are the steps being taken.
So far as regard
Huh?
the appellate forum is concerned, Lord, we all know, Lord, if there is no order of stay of
Then-
the lordship's order, Lord, then the authority is
Okay, we will see to that. What are the dates being fixed? Thereafter, we'll proceed.
will kindly grant me some more time.
I just require what you have stated and submitted before this court to have a comprehensive report on that aspect only. The status. Let them have a look to the what is the status. Then we'll decide.
Report simplicity, I'll come back in form of affidavit, I will kindly give me time. If I report, let us see Lord, where we stand, then we.
Okay.
if my friend Lord can serve and Lord advance copy of so that Lord I can come.
Learned advocate, Mr. So-and-so, learned advocate for the state respondents, submits that the direction passed with regard to, with regard to under the Act of 1964 has been carried out. However, the same could not be concluded since some of the aggrieved parties have preferred appeal before the Honorable Division Bench. He also informs the court that steps under Act of 1962 has also been initiated. He seeks to submit a comprehensive report disclosing the status of both the proceedings. Let such report be filed next week, 11 December. Give a copy also to
Order that indicates since all of the parties were being represented, lordships give them an window so that 2 weeks after the ensuing the election, that process can be completed. So the question of communication thereafter on my part doesn't arise. Subject to correction, I shall come back.
they let them come up with the report. 11.
Well, let such report filed.
By the
What do we say?
on the returnable date. By now on the returnable date. Reach this matter on 11.
Item number 5.
My lord, I am for the petitioner led by Mr. Sabir Ahmed. Today was the date to file affidavit in reply due to some personal difficulty of the client.
The topic
who
on
filed it. Can you please fix the date, my lord?
take it. On the prayer of learned advocate for the petitioner, list this matter in the on the prayer of learned advocate for the petitioner, list this matter in the monthly list of January.
File it with a short date, my lord. Next week.
यार टॉपिक क्या नोट की स्टार्टिंग में चाहिए नहीं ফেব্রুয়ারি মাসে শুনেছিলাম দেখি ওই দিনে শুনেছিলাম কিনা দেখি তো পান তো আর্গুমেন্ট করছিল আচ্ছা 6 you'll be filing what
Affidavit in reply.
reply to the
Opposition.
Mr. Swensolane কেটে দিন তো ওটা Mr. Swensolane advocate for the petitioner 6 extension of time affidavit is supplementary as well application to file affidavit in reply to the affidavit in opposition filed by the state respondents. 2 weeks করে দিন let such a reply be filed within a period of 2 weeks. List this matter after 2 সপ্তাহ পরে after 2 weeks.
Item number 6.
My lord, I'm led by Mr. Chitrapriya Bhashwati. My lord, as per the last order, my lord, there was a direction for a joint survey.
What?
As per the last order, my lord, there was a direction for the joint survey report. The report shall be filed by the
Joint survey by
state, my lord, and the railway authority.
Your lordship. বলে দিতে হবে
Yes.
Your Lordship, Mr. Joyanto Shamanta appears for the state in this matter. This is the report on behalf of the state.
Kindly direct them to give us a copy, my lord.
So I have a copy right here.
এটা কি দিল?
Kindly give us time to go through the report.
Who is for the railways? You have given this?
Some
সিগনেচারও আছে বাট টাইম কিসের? কৃষ্ণার তো নিজেই জানে কোনো অ্যাপ্লিকেশন নেই, আবার টাইমের কি আছে?
G problem. There are no encroachment now.
There is no encroachment, Your Lordship.
Yes.
Mr. Ghosh is before courtroom number 8. My lord, kindly adjourn it or make it a short passover. Let him come.
Your Lord,
Led by
the
him.
joint inspection was conducted in January. The petitioner himself was present at the time, and as were the parties of the other respondents. All of the parties were there. Everyone is very clear upon the subject that there is no encroachment, no no land of the petitioner has been acquired in respect to this matter, Your Lordship. It is very clear. The sketch map is also there. The sketch map shows the boundaries, and the signature of the petitioner is also there at the left bottom corner of the map.
Then
My lord, I'm led by him. Short passover or kindly.
Your Lordship, nothing remains in the matter.
My lord, I also know, but
difficulties. Where is he? He has not come.
he has come. He's before courtroom number 8, my lord.
So dispose of this writ petition.
If there is any discrepancy in the report, then kindly give a liberty so that I can come back. That's
Your Lordship, there is no.
You were there at the time of inspection. You were there.
no, my
You were
Your
not there.
Lordship, the petitioner was there. The petitioner was there. Kindly see the map, the sketch map, Your Lordship. The petitioner's signature is there on the left bottom corner.
I'm not denying that, my lord, but if
Passover Raghunti. Call him. Ask over. Holy Trust School.
Item number 7.
I appear for the. This matter was mentioned by us. Now, initially the. In order to. An order of 2nd of November 2016, the writ petition was dismissed. We didn't appear where we appear, whatever we could not make our submissions before the court, it was dismissed by Justice Bosch. Thereafter, we preferred an appeal from that order because the order was on merit. The appeal court's order is 25th of June 2019. Justice Sen sitting with Justice Kapoor in the division bench. So here the writ petition was restored in 2019. This is 2019, the writ was restored for a fresh hearing. Now, there were directions for affidavits. In the meantime, the state, the Urban Development Department, who is a concerned state department here, he has filed an opposition. We have filed a reply. Now, the other respondent is the Bidhannagar Municipality. The writ petition refers to a land in the Sector 5 area in Salt Lake. So, the Bidhannagar Municipality and the UD are both necessary parties.
The lease has been resumed.
The writ petition needs to be heard once again. The order
The
of the
grievance is that the lease has expired or it has been cancelled. It is that case.
Lordship is. Oh, the prayer in the writ petition. Sorry, ma'am. Oh, the prayer in the writ petition. I'll come to that, ma'am. The government, the Urban Development Department allotted a land, around big land, to Bidhannagar Municipality for construction of a school in Mohishbatan, Salt Lake. It's between the UD and the municipality for the to construct a school. The municipality said that I don't have fund, I cannot construct the school.
The UD said that you take your self-initiative and do the needful. Bidhannagar municipality published a tender in newspaper calling for private bodies to come and join so that a school building can be constructed. My client is that private body who participated in the tender. I'm a Section 25 company being an NGO. So I participated in the tender. I was selected. Once I was selected, a MOU was entered into. In the MOU, the understanding was the big land, I'll construct two school buildings. One for me and one for the municipality at my cost. Free of cost, the municipality school building, I'll give it to the municipality. It will be a 5-storied building for the municipality. At my cost, I'll construct and give it to him to run. And so, for my school is concerned, I'll run myself. And there will be a common playground in between, because the playground is compulsory because CBSE and ICSE registrations is compulsory. So that the map, everything is done. I entered into an agreement. Now, I said that the municipality said that there will be a sublease in my name, because a portion which the school building stands in my name, around 34 katas of land where my school building stands, so sublease has to be executed by municipality in my favor. Being the land under UD and lease, so municipality need a permission from the UD. Entire Salt Lake lands are required like that you need a permission from the urban development for sublease. And this permission comes at a payment of fees. There's a fixed fees of residential, of industrial, of institution. So 3 categories of fees are there by the government. So as school, we come under the category of institutions. So 5 lakhs or 7 lakhs, whatever. The fees is there. When municipality applied before UD for this permission, UD was sitting tight over the matter. He did nothing. I come to court. First round writ petition. Justice Joyanta Biswas was sitting tight. Order passed. Kindly hear both the parties and pass a reasoned order, because you can't sit tight over this matter. So, hearing was given, all the parties, and a reasoned order was passed by Urban Development Department, the UD department. The reasoned order, Urban Development Department refused to grant the permission to municipality. Now, what happened in the meantime? Municipality and both myself were under the belief that this will be a formality, because between the government, 2 government departments, I was given possession of the land. Documents are there. I have been given a plan sanction was done up to the first floor level. I was even say you go ahead with the construction. So I have put in a boundary wall, some underground plinth work and everything is done by me. At this stage, the work stopped because the legal issues cropped up. The permission was not given. The order which I am challenging, the difficulty is the state. In the meantime, the advocate on record of the state has got all changed. Because the
Mr. Sengupta was there.
Yes.
In appeal, Mr. Sengupta appeared.
Shobhan Sengupta is still there for the state, which I find from the order of the division
Appellate,
bench.
yes.
And Mr. Bhattacharya is no more in the municipality
so?
panel that I am there. So, I don't know whether, so far the state is concerned, I believe the state AO must be
But
on
then
record.
Any panel of advocates for Bidhannagar Municipal Court?
Serve them, because I can serve the government pleader for the state. But for municipality, I need to serve the municipality. Or Lordship Alderman,
So corporation was given liberty to file affidavit in opposition in the
yes,
appeal.
I know, but for me is also a change in advocate, and I'm not very sure whether that opposition is on record. If it is on record, my lord, we can take a certified copy. Because for the state, I know it is there. But
I
municipality,
think again they will go back to the appellate court to have the extension of time to file affidavit in opposition. Because that is a peremptory.
yes, I've seen that. I've seen that.
To give a
But
notice.
Lordship, kindly, একবার দেখুন দেখুন না opposition আছে কি?
No, Bidhannagar has not filed opposition because
The
they have prayed for extension of time before the appellate court.
appellate court.
So they have not filed.
No.
Whether they have filed in the meantime after disposal of the appeal, that is the concern.
Yes, must be in the department.
Give a notice.
Yes,
Let them come.
yes.
first, huh?
Let them come and they will say.
Hmm.
I may have misplaced it. I don't
Sir,
know. I may have.
Aniruddha Mitro, learned senior advocate, appearing on behalf of the petitioner, submits that the writ petition has been restored. Sorry, the order restored again. The order dated 2nd November 2016, by which the writ petition was dismissed, has been set aside by the appellate court. The writ petition has to be heard on merits. He seeks to serve notice upon the learned advocate for the state as well as upon Bidhan Nagar Municipal Corporation. Is the respond number? Bidhan Nagar is respondent number
4.
4.
Then another municipal corporation. Put 5 and 6 are all the municipality and the corporation and its
The
officer.
respondents Bidhan Nagar Municipal Corporation. Let such notice be served upon the state as well as Bidhan Nagar Municipal Corporation by the returnable date. Please this matter জানিতে দাও 11th না দিয়ে তার পরের উইকটা দাও সার্ভিসটা করে আসো তার ডেট ফিস you took so much time to mention before this court 5 years it took
There's no explanation. 19th,
16th
16 January, December.
let them come thereafter will
Let them
what is
come
the
as-
position
Yes,
Yes.
that's our clients, whatever.
okay
Yes. Live there.
and congratulations to you
Same college. Can it be on 17th? Can it be on 17th, Malars, other than 16th?
17th দিয়ে দিন 17th
17th হবে? Fine. Okay.
Item number 8.
This matter was mentioned upon notice for
here for whom
the repetition.
come this side the yes
Someone kindly looks into a coordinate bench order passed in the proceedings.
dated
Order that's 2nd September 2018. The present petition is launched against the order dated 30th August 2018 passed by the Petitioner Magistrate Jalpaiguri.
wait 2nd September yes sir
This order was made by this honorable court. Kindly see below, it was an unlisted document and it was made on a Janmashtami. 2nd September 2018 was Janmashtami because they were merely proceeding to raise the structure standing on the land, the ground on that particular day. Now, please see the present petition is launched against the order dated 7th passed by the subdivision magistrate 7th to vacate and deliver possession of the or sheet number 2 Commandant SFT Proceeding. But further indicated there that the failure to deliver a possession the specified time we invite the enforcement of the said order to the MPT possession. A copy of an order dated 28th August 2018 passed by the
for the state
deciding to take further steps to order. The present
so the demolition is to be carried immediately after
the revenue under the Eviction Unauthorized Occupants Act 1960. The demolition is to be carried out immediately after 1st September The writ petition was filed by the Honorable Chief Justice. On a basis, the Honorable Chief Justice granted these petitions to the court since evidence has been found by the Honorable Chief Justice. The assignment court compliance with it appears to have checklist of the authority. Proposed notice was issued by the collector under section 3 as it is opinion the petitioner in unauthorized occupation of the land in question and provided with the right to see. Petition of particular to Section 7 provides a very right to the chief commissioner or the division. The order is asked by the collector the district by accepting said after authority initiated disposed of the appeal on 1st June 18, dismissing the same, which was challenged by the petitioner in WP number 36. The said writ petition was entertained on 4th June 2018. Restrained also the order. The said petition ultimately came for the 15th of June and was disposed of by setting aside the order as the said order was bereft by the findings reasons. Matter was remanded to the appellate authority, considered afresh after giving opportunity of hearing to the petitioner and to be disposed of within 4 weeks from the date of publication of law. My attention is drawn to the various documents annexed to the petition, wherefore it appears the appellate authority takes the appeal inquiry conducted to decide the order. Finally and according to the petitioner, the same was done. The appeal was fixed on 17th July and was concluded, but no order was passed by the appellate authority. Said appeal is disposed of on 28th August 2018 and its statement makes paragraph 35 of the petition or court agrees to correct. The said order of the appellate authority the authority has asked the order to communicate the same to the affected party. It cannot file an application before the state government within 30 days. Within 30 I'm sorry, madam. Affected party cannot have any legal efficacy. The reference will be made to such and such charges. The acquisite view is reiterated in such. Further, I'm reading the last part of the after the quotation. Further, the authority, while keeping the said order with has hastily proceeded to pass an order for taking delivery of possession without giving a reasonable time to the petitioner to take steps permissible by law. Section 7(2) of the Act provides further remedy to any person agreed by an order of the appellate authority to file an application to the state government from the said order on such ground of gross error of facts or law. Such statutory right not be frustrated by keeping the order of the appellate authority to file and proceeding to take delivery of the petition. There is another reason which this court feels invites interference with the order. My attention is drawn to the declaration of the section 6 of the Act of August 1. The petitioner contending before the authority of the court was never subject matter of application and was never recorded in the main state. The plot of land is not included in the certificate under section 4. All the declaration under section 6, the authority must record of all these findings by such property the public property of the authorized. This court therefore finds strong findings that shall be clear out in order to get this. 4.6 RS court number 122 in Cycle is concerned for a period of 7 years. The proposal order is fast food grant statement development petition on 4th. The seat which to and correct. Petition is directed to serve copy. The matter is made to the house. When this order was passed by this honorable court, by that time, Milord, the building was raised to the ground.
Yes.
And therefore, Milord, it prompted us to file appropriate application in connection. And Milord, in connection with one such application, Milord, please take the trouble to come to an affidavit found by me the month of September 2018. 7 September 2018. As my not very kindly got 7 September 2018.
7 September or 10 September.
Affidavit on behalf of the writ petitioner.
7 September. Here's a copy. Copy of that order. 7 September order copy.
No, not order. Well, I'm saying an affidavit found by me on the 7th.
Oh. Seven September, yes. Sukhendu Bhaumik. What is his name? Gautam Ghosh. Gautam Ghosh. Yes, yes.
This affidavit was found on the 7th of September 2018. Now please see paragraph 2 on
Who is for the state in this matter?
kindly see previous orders made by your lordship support in the proceedings. I invite my lord to an order dated 2nd May 2023 passed by a coordinate bench. All sorts of notices. Mr. Bhattacharya, learned advocate for the petitioner, is present and has handed over a received copy of letter dated 1st May 23 addressed to Mr. Nag, learned advocate appearing for the state. In spite of such notice, none appears on behalf of the state. Affidavit in reply as filed by Mr. Bhattacharya is taken on record. Before the hearing, he draws the attention of this court to the order dated 2nd September 2018 as passed in decision by a coordinate bench of this court, wherein an order of stay was granted in respect of the order dated 30th August 2018 as passed by the substitution magistrate. The previous order sheet which reveals on behalf of the state, Learned Advocate General, Mr. Bandyopadhyay, Senior Standing Counsel of the State, and Mr. Nag appeared in the incident. Really unfortunate state that even after service of notice on behalf of the petitioner, here also we have served notice before mentioning. None of the case will appear on behalf of the state for ends of justice inclined to pass the orders today. Accordingly, let the matter be listed under 7 sub. If made clear that even if the event none appears on behalf of the state, the matter will be hard. Department is directed to forward a copy of this order to the office of the Learned Government Leader High Court with a request to the Learned Government Leader to ensure the readiness of the Learned Active of the state. Department is further directed to forward a copy of this order to the respondent numbers 3 and 4 with a direction to the respondent numbers 3 and 4 to ensure that they are represented before this court on the next date of hearing, failing which this court will be compelled to take coercive action against the respondent number 3 and 4, that is the district magistrate and collector Jalpaiguri and the sub-divisional magistrate judge. Department is directed to forward a copy. Now, this order was complied with. Thereafter, the matter appeared on a number of occasions before a coordinate bench for some undisclosed reasons. The state chooses not to represent themselves. When I mentioned the matter before your lordship court, also it was mentioned on notice to the concerned advocate themselves. And they are still in the panel. They are very much appearing for the state every day. But for some undisclosed reasons, they chose not to appear. And my lord, I invite your lordships also guide attention, my lord, to a coordinate bench's order, my lord, dated 13th of September 2018, when this affidavit, my lord, attention of which was drawn to your lordship, my lord, kind attention was drawn. That affidavit was taken on record on the 13th of September 2018.
Why they are not appearing?
Right. I have no idea.
No.
In terms of the order made by your lordship's court
This was the respondent.
on the 2nd of May 2023, the respondent number 3 and 4, if they are called upon to attend, then only perhaps the state will enter appearance. Otherwise, they chose to remain unrepresented on a number of occasions.
State কি আছে এখানে present? Anybody from the state panel?
Bari is here.
Mr. Shirshonna Bandyopadhyay, Mr. Kishore Dotto also appeared on behalf of the state. This is also recorded. No, that is not the issue. Issue is that the petitioner, one after the other, is informing the court's order are being communicated to the district magistrate. Now, what is this happening? He has a right, he doesn't have a right. This is to be decided by the court. But why after service of the notice, the state is not represented? Whatever you have to submit, come up and make your submissions. One after the other, the court has given. Then
or the GO standing down. To at least send someone to your lordship's court to assist the court at 2 p.m.
At 2 p.m. it will not be possible.
At 1 p.m.
Day after tomorrow, then at 2 p.m.
Very well. No problem.
Sir Vishwaru Bhattacharya, learned advocate for the petitioner, submits that by the present writ petition, the writ petitioner has challenged the order dated 30th August 2018, passed by Subdivisional Magistrate Jalpaiguri, directing to vacate and deliver the possession of RS plot numbers 121, 122 and 123 under Mauja, Binnaguri, District Jalpaiguri. By order dated 22nd September 2018, an interim order was passed. Thereafter, the state, the advocates representing the state respondents, in spite of getting several notices, have not appeared, due to which the hearing of the matter has been delayed. In his usual fairness, he seeks to serve. Who is that? Mr. Bandyopadhyay?
I'll serve both Mr. Nag, Mr. Bandyopadhyay.
Okay.
And I'll request my learned friend to personally go and serve them, not through the clerk. We'll personally go and request them that my lord. Otherwise, your lordship kindly may not indicate something in your lordship's order that in the event they choose not to represent themselves.
So that is there in the order dated 2nd May 2023. You give a notice. You give a notice to Mr. Bandyopadhyay and Mr. Nag. Huh? Otherwise, we have to hear it out. Serve notice to the learned advocates who represented the state respondents. Place this matter on Wednesday to দেখো second half কি আছে হবে সার্ভিস যদি এসে যায় তাহলে pleadings are complete. They have filed their opposition.
Yes, they have filed an opposition. We have used our response.
Okay. Wednesday to just to be mentioned at the end. To be mentioned on Wednesday.
As your lordship, please. I do not.
To be mentioned on Wednesday. If they come, fine. Otherwise, we'll fix a date for hearing on that day. You just intimate them. The short date একটা করে।
Item number 9,
I appear for respondent number 6 and 7 in the second matter.
He has also concluded.
Exception.
Today you will argue, Mr. Pinaki. Mr. Chakraborty, you will make your submissions today.
But I was directed to file an affidavit in opposition,
Huh.
but I have just told, I am told by Mr. Ganga Prasad Mukherjee, who is also with me, and it has not yet been affirmed.
Then this is hearing one matter, then other matters you will file oppositions. This is taking time. No?
I have an exception to the
You served, copy served upon you.
Now I have
Mr. Chakraborty, can it be filed in the course of the day?
But I have told that it is ready, only the affirmation is.
It has not. Okay. Today it is being affirmed. Because until and unless that comes, we cannot take his exception to the record.
By tomorrow, I think it will.
Tomorrow?
By tomorrow, I shall tell them to come.
I am suffering an interim order as casual.
Tomorrow.
Which of this
কালকে রাখো তো,
is
not
really prejudicing me.
কালকে রাখো না। আজকে not today করো।
It has to be done by tomorrow, will it? Otherwise,
I do understand.
By tomorrow, I shall try to get it done.
Get it done. Do not try. Get it done because one party in the petitioner has completed his argument and he is also ready with the exception.
I will keep it on Wednesday.
Tomorrow.
I'll keep it on Wednesday. I think by tomorrow, I am getting it done. I shall serve copy and kindly keep it on Wednesday.
Mr. Pinaki Ranjan Chakraborty, learned advocate, appearing for respondent number 6 and 7, Railways Authority.
Second matter, WPA 2910. The first I think date is not part.
no. So that's only not to help. Which one?
No. Affidavit in opposition. There was no such direction upon the railways to file any opposition. Where is that?
You have to kindly see the order in WPA 29103. But sir,
The second writ petition.
Have you filed on behalf of respondent?
এটা
29103, you are respondent number 6 and 7.
শান্ত পণ্ডিত ভার্সাস স্টেট অফ
No. No, there was no such direction to file affidavit in opposition. Your report was taken on record with a direction to file exception. There was no such direction to file opposition. And the report as submitted in the other writ petition, that was taken on record. Yes, file your exception.
have already filed a report. And they've gone far ahead by
The
stopping my
reply
construction
and
the season of this matter.
affidavit reply. The business is taken on record. এটা কি রিপ্লাইটা কিসের আসছে না? Who is for the state respondents? Where is your reply?
Submitted the application for no such complaint has been for the subject.
Only you sought time to file affidavit in reply. Where is that reply then? Are you going to file any reply or no?
Submitted now.
I am talking about affidavit in reply. Will you be filing any reply? No. কি বললাম? হ্যাঁ। No, 6 and 7 কেটে দেন। This is Sudeep Sannal, learned senior advocate, appearing on behalf of the your respond number
8 to 10.
8 to 10 finds 8 to 10 in
Second,
8 to 11 8 to 11 in WPA 29103 of 2023 files exception to the report filed by respond number 6 and 7 railways authorities. Yes, Mr. Chakraborty. Railways report তো একটু দেখো তো কোথায় আছে রেলওয়েজ এর রিপোর্ট দেখো 29 রিপোর্ট পেয়েছো রিপোর্ট দেখো তো। Why Wednesday? Today? দেখো তো রেলওয়েজ inspection report রেলওয়ে একটা রিপোর্ট আছে বাই রেলওয়েজ Yes, please share up. Yes, Mr. Chakraborty, what is your submissions?
Not my first objection is that the railway exception that is to be protected. The municipal authority is not a jurisdiction of railway. The regulations, they are not a guide to construct a building. What will be the distance from the main road? Objection purpose is that in case of any demolition or any destruction, the pathway of the railway track must not be affected. Yeah, I see. On our measurement, it was the report we have filed. Only 2.6 meters away from the railway boundary, very close to the railway track. They have raised the question whether the railway manual is binding on them or not. The first question is that it is not an idea that the municipality law, the corporation, they are the authority control that those things. And for the purpose of obtaining, it is necessary to obtain a sanction plan from the municipality, and that's all. Now, it is the duty of the municipality before granting sanction to any plan to see all the circumstantial situations, whether the building is to be granted such permission or not, or what. They have made an appeal. They are saying that it is not binding. I have the correction. When there is a railway track very close to the plot of land, it is the duty of the municipality. There must be a harmonious application of all. Some may be state law, some may be central law. If permission is granted in such a manner that within 2.2 meters, a large building is constructed. That tomorrow an earthquake takes place, or any destruction in any manner, or because of the mega construction and defect the building collapse. Apart from the other questions of loss of life and property, the railway track will be destructed. If the train is there at that point of time, there shall be more loss of life. Therefore, that question, whether it is applicable or not, that is to be considered under some broader aspect. It is a fact that at the time of construction, no permission from railway under the municipal law is provided. But the railway manual says that no objection is to be obtained if it is within 30 meters. And any law of land is applicable to all the citizens of it. Since it is not provided separately in municipal law, therefore I am not under obligation to comply. I do not agree with that point, and it was the duty of the concerned person before construction to obtain a clearance. Ignorance of law is of no excuse. He says that it was not widely circulated. I do not know all these things. Admittedly, it is violative of the railway manual. They did not apply for no objection. We did not make any court inquiry before construction. It is not the case that railway granted any permission. And if in the event of collapsing of the building for any reason whatsoever, there is no doubt that the railway track shall be added. So, because I am supporting the case of the petitioner, it was the duty of the concerned developer as well as of the particularly of the municipality take care of this point. Had there been a case that the municipality before granting the sanction, a spot inquiry was made, they could have understood that if the construction is being announced, that will be a risk for the railway. Therefore, there is a, if the building is allowed to be taken, the railway track and the will be at risk.
Okay.
That is my submission, and there are other violations of the municipality and petitioner. They shall go to that. Only so far as the interest of the railway is concerned, I have made my submission.
Okay.
And I am supporting the case of the
Perfect.
As I understand it, there are two writ petitions before your lordship.
And before you start, you will make any submissions? You are also a respondent? Yes.
After finishing, I have been submitted. Or if you are not submitted, municipality made an application for construction. That is in the year 2000.
Okay, let him submit.
As I understand it, there are two writ petitions before your lordship. And one of them is on the point that there's a violation of the municipal rules, and under section 218 and 217, they should be demolished. Then he went on further to say that there is a railway track that is not in the first record. So there's a railway track nearby, about less than 30 meters, and therefore no construction should have been allowed without the permission of the railways. The second writ petition is primarily on the ground that there is a railway track nearby, one, and there was not much space left according to the railway manual. Now, your lordship will remember one thing before your lordship goes on to the second writ petition, that there's no application before the railways by any of these respondents. They've just extracted some information under the Right to Information Act. And I'll go through that copiously before I address your lordship on that. And that on the second writ petition says that there is not much space left. There's only 4 feet space left. And he says it should be 4 feet space between the two houses, which the municipality says, yes, there is. There is. After inspection, there is 4 feet gap. And in the first writ petition, which I'll point out before your lordship that photographs, the writ petitioner, he doesn't say he's the owner of the adjacent building, number one. And he does not also specify as to how much he has left, because he is not the owner. It is actually some from the second writ petition I could get it, because they are working in concatenation, in connivance with each other, all of them. I'll show your lordship from evidence which will be there before your lordship, that there is Thakurbai, and an address of the first writ petitioner is given in that particular address. But then after that, he doesn't specify anything. He's just saying that he's a neighbor. And I'll show your lordship the photographs to show that he comes to seek equity. He comes before this court, but he doesn't come with clean hands, because he himself has not left the specified gap between the wall and his construction. Now, after that, he comes and says that this is should. And I'll show your lordship that there is adequate. On his side, I have left adequate. The other side, he cannot espouse the public cause, because the public is not right. I'll show your lordship that. But my first point would be, that is the first point. I think he took 2 or 3 points that way. And 217, he took section 217 to say that I had suppressed facts and that it should be demolished. That's not the case. I'll show your lordship. Now, first argument would be about the railways. How do they crop up? Because it is absolutely interesting. Wait, railway report ka kotha hai? Your lordship kindly comes. That is going to be my first point. Your lordship kindly comes to Annex P1, page 4, the report of the railways.
Yes.
Now, if your lordship sees the date, that is 18/11/2024, the date. And what does he say? This is the senior section engineer. Now, your lordship was hearing this matter. Your lordship had just asked him to file a report. What does he do? He goes further. As no NOC has been obtained for construction of the above property, therefore it is being advised to stop the work till proper NOC is being obtained from the competent authority. Now he passes an order for stopping construction. When your lordship, when your lordship was in season of this matter, this matter was being heard, and your lordship sees he is a senior section engineer. I will show your lordship that this order is absolutely invalid. It should not come, because I'm afraid that they might say that you have to challenge this order and again another writ petition. But since your lordship is in season of this matter, it has come up as an affidavit before your lordship during the course of the hearing. Your lordship will kindly deal with this matter. Now, if your lordship kindly comes to the Municipal Act.
You have Mr. Mughal. ওখানে বলকে ওই যে ওখানে দিচ্ছে আছে আমাদের মিউনিসিপ্যাল অ্যাক্ট আছে
না থাকলে আমি দিচ্ছি এখানে দিচ্ছি আছে
ওকে
So your lordship will kindly come to section 6.
yes
On the expiry of 30, I'm just reading a bit, preparing a background. On the expiry of 30 days from the date of publication of the notification in the official gazette, and after consideration of all or any of the objections which may be submitted, the governor may, by notification, constitute such town or any specified part thereof a municipal area with a specific nomenclature under this act. So is the governor who's to do it under the act. Provided that the governor may change the nomenclature of a municipal area under this section. Provided further that for change of nomenclature of a municipal area, the provisions of section 4 and section 5 shall mutatis mutandis be followed. Thereafter, now, 7. The state government may, for the purpose of application of the provisions of this act, classify the municipal areas into the following groups on the basis of the population as ascertained at the last preceding census, of which the relevant figures have been published. A. Group A, municipal areas having a population of so and so, so and so, so and so. So your lordship sees that this is what the state is doing. It is the state which is doing this. It's the municipal area which is being defined. Because one municipality can't come into the other. There's no question of any other person being affected, even if it's the railway, it's within the municipal area. And thereafter, provided that for the purpose of classification of municipal areas of the hills, so and so, power to determine the number of wards. Why I'm showing you, your lordship, this is because this is absolutely a state subject in the second list, schedule 2, schedule 7. And even the central government, if it wants, it can't legislate. It is incompetent to legislate. Now, if your lordship kindly comes, your lordship sees power to abolish, 8. Power to abolish or alter the limits of a municipal area. The state government may, by notification, that's 8, withdraw any municipal area from the operation of this act, or exclude from a municipal area any local area comprised therein and defined in the notification. Or and so. It has the power. State government has the power to give municipality, and what it gives is a delegated legislation to the municipality, but it is right at the top to take the decision, to formulate this act, to make the rules. No other person can do this.
yes
আমাদের
এটা হবে দেওয়া আছে So if your lordship kindly takes the Constitution of India, your lordship has a copy.
constitution এখানে
Oh, I'll hand it over. I'll hand it over, your lordship. It's marked in blue.
এই তো কনস্টিটিউশন অফ ইন্ডিয়া আছে কেন এই তো দেখা যাচ্ছে চলে আসুন এইদিকে বাঁ দিকে লেফটে আসুন এই তো ব্যাস ওই এইখানে না পাশেরটা ডান দিক দিয়ে
Marked in blue.
yes I've got it
So therefore, since the municipality, in fact, if the municipality was to pass such a notification that you have to take permission from the railway authorities, I would have filed a writ petition. as to the competency of the railway authority to lay down any rule. I would have done it because of the fact that it would be within the municipal subject and something that is not within the list either in the 7th schedule. That can't be done. There's a separation. And now I'll show you Calcutta gas. I'll go on to the aspect of a manual not being binding or not being a law, not at all a law. And what we are supposed to follow is the law. Something laid down by Parliament or by delegated legislation, something that's by the that is also seen the light of the Parliament or whatever, unless it is. But I'll show your lordship the manual which they are depending on is communication from one officer to the other. That is what I'll show. But here, your lordship will kindly consider this. Okay. Now, this was a case where gas was supposed to be an industry, gas industry. Now, the state government took over the Calcutta gas by notification. That was challenged. And the court found that, yes, this is an industry under the state list, and therefore, a notification by the central government under a different act could not be said, could not be valid. Now, this is, AIR 1962 SC 1044, Calcutta Gas Company. 1044. If your lordship kindly comes to paragraph 9. On the, I am reading towards the end. Towards the end, about 1, 2, 3, 10 lines from the bottom. Paragraph 9.
Yes.
On the other hand, the alternative contention enables entries 24 and 25 to operate fully in their respective fields. While entry 24 covers a very wide field, that is, the field of the entire industry in the state, entry 25 dealing with gas and gas works can be confined to a specific industry, that is the gas industry. There may be many good reasons for the authors of the Constitution giving separate treatment to gas and gas works. If one can surmise, it may be that as the industry of gas and gas works was confined to 1 or 2 states and was not of all India importance, it was carved out of entry 24 and given a separate entry. As otherwise, if a declaration by law was made by Parliament within the meaning of entry 7 of entry 52 of list 1, it would be taken out of the legislative power of the states. Be it as it may, the express intention of the Constitution is to treat it in normal times as a state subject, and it is not in the province of this court to ascertain and scrutinize reasons for doing so. So therefore, municipality is within state list. So we need not ask ourselves as to why did it say. So after that, the main thing is there are emergency powers and etc., etc. Then after that, your lordship kindly comes to paragraph 11 straight away. Nor is the contention
Para 11.
Yes. Paragraph 11.
Yes.
Nor is the contention of learned Attorney General that Section 20 of the Central Act would still be valid vis-a-vis gas industry has any force. under section 20 of the Central Act, after the commencement of this act, it shall not be competent for any state government or a local authority to take over the management or control of any industrial undertaking under any law for the time being in force which authorizes any such government or local authority so to do. Thereafter, we have expressed the view that the legislature of a state has the exclusive power to make law in respect of gas industry by virtue of entry 25 of list 2, and the entry 24 does not comprehend gas industry. As we have indicated earlier, the expression industry in entry 52 of list 1 bears the same meaning as that in entry 24 of list 2, with the result that the said expression in entry 52 of list 1 also does not take in a gas industry. If so, it follows that the Central Government Act, insofar as it purported to deal with the gas industry, is beyond legislative competence of Parliament. So, your Lordship sees even that is an act. This is just a manual. It's putting a restriction. It's taking away my right under Article 300A to build. They have not acquired it. Now, if your Lordship kindly imagines this situation, 30 yards, 30 meters away from the railway tracks, they don't acquire it. They're at liberty to acquire it. Otherwise, they can't injunct me from building. I can't make a playfield on my land. It can't be kept as a playfield for common benefit. That's what they want to do. Oh, it was your Lordship. And that is why these people have come up, the other writ petitioners. They were enjoying that playfield, which I have built for. Now, after that, if your Lordship, can I read it further? Section 20 is an integral part of Central Act, and it is, if it is taken out of the Act, it can only operate in vacuum. The said section was introduced for the effective implementation of the provisions of the Central Act. It was also enacted by virtue of entry 52 of list 1 of the 7th schedule to the Constitution. If the Act was constitutionally void, insofar as it purported to affect the gas industry for purposes, for aforesaid reasons, Section 20 would equally be void to the same extent for the same reasons. In this context, now your Lordship will kindly read this along with me, Millard. In this context, two decisions of this court, namely Raghuveer Singh versus State of Ajmer, 1959 supplementary 1 SCR, and State of Bihar versus Umesh Jha, may usefully be consulted for the said decisions. For in the said decisions, this court held that ancillary provisions enacted for carrying out the objects of a main act would fall within the main act on the ground that they were enacted only to subserve the purpose of the main act. Section 20, therefore, will not avail the appellants to question the validity of the second state action. Now, that was what was being submitted, that the municipality should have taken note of it. What's this? Nothing to it.
Yes.
Central government has no legislative competence to do that. Next one. Nothing. Now, I will come on to the next objection as to this manual. There's no statutory force. Because that was a manual which was extracted and been touted before your Lordship as a law, which it isn't. This is your Lordship kindly sees this judgment of the Supreme Court. 2007 8 SCC 212. 2007 8 SCC 212.
218. Yes, page number?
Yes, page number 212.
Yes.
If your lordship kindly comes to paragraph 19. This is also the railways. We have carefully gone through the contents of various chapters of the Vigilance Manual. Chapters 2, 3, 8, 9, and chapter 12 deal with Railway Vigilance Organization and its role. Central Vigilance Commission, Central Bureau of Investigation of complaints by Railway Vigilance, processing of vigilance cases in Railway Board suspension, and relevant aspects of Railway Servants Discipline and Appeal Rules 1968 as relevant to vigilance work, etc. Paragraphs 704 and 705, as noticed earlier, cover the procedures and guidelines to be followed by the investigating officers who are entrusted with the task of investigation to trap cases and departmental trap cases against the railway officials. Broadly speaking, the administrative rules, regulations, and instructions which have no statutory force do not give rise to any legal right in favor of the aggrieved party and cannot be enforced in a court of law against the administration. The executive orders, appropriately so called, do not confer any legally enforceable rights on any persons and impose no legal obligation on the subordinate authorities for whose guidance they are issued. Such an order would confer no legal and enforceable rights on the delinquent, even if any of the directions is ignored, no right would lie. Their breach may expose the subordinate authorities to disciplinary or other appropriate action, but they cannot be said to be in the nature of statutory rules having the force of law subject to the jurisdiction of certiorari. It's well settled that the central government or the state government can give administrative instructions to its servants how to act in certain circumstances. But that will not make such instructions statutory rules, which are justiciable in certain circumstances. In order that such executive instructions have the force of statutory rules, it must be shown that they have been issued either under the authority conferred on the central or the state government by some statute or under some provision of the Constitution providing therefore. Therefore, even if there has been any breach of any executive instruction, that does not confer any right on any member of the public to ask for a writ against the government by a petition under Article 226 of the Constitution.
Yes.
Now, let's go on to the next one. Closely following. Not that. Anything to bind anybody must be published. Even if your lordship remembers, there are judgments. An appointment letter is issued. Before it reaches somebody, it's withdrawn. No appointment. Got no force. A person is dismissed from service. And that is kept in the file, but not communicated. Doesn't take effect. that is the administrative part. Now, to make a law, there must be publication. That is under section 23 of the General Clauses Act. Now, this has been, Miller, if your lordship, I'll address your lordship on that, if your lordship so wants. But this has been set out in Harla, and there are other judgments. So Harla 1951, SCC 936. 1951 SCC 936. Anything that is a law or a rule must be published. That's the natural corollary. At the moment it's published or made known, it takes. But it must have parliamentary sanction or must be made under the powers that are under the Act. And then after that publication, laying before the Parliament for that. Just a notification kept in the drawer of all railway servants will not do. Now, if your lordship reads this, may I read, paragraph 3. On 11/12/1923, this council passed a resolution which purported to enact the Jaipur Opium Act, and the only question is whether the mere passing of the resolution without promulgation or publication in the Gazette or other means to make the act known to the public was sufficient to make it law. We are of opinion that it was not. But before giving our reasons for so holding, we will refer to some further facts. Your lordship need not be troubled with those facts. Now, your lordship kindly come to paragraph 8. We do not know what laws were operative in Jaipur regarding the coming into force of an enactment of that state. We were not shown any, nor was our attention drawn to any custom which could be said to govern the matter. In the absence of any special law or custom, we are of opinion that it would be against the principles of natural justice to permit the subjects of a state to be punished or penalized by laws of which they had no knowledge and of which they could not even, with the exercise of reasonable diligence, have acquired any knowledge. Now, with reasonable diligence, I know only one person whom I have to approach for a building permit or a building sanctioned building plan. That is the municipality. And I've approached. If you have anything, put it up to Parliament. Take an injunction. Let's see. That has to be made a law. It has to have enforcement. It has to be enforceable. Your lordship has seen it is not enforceable. Now, after that, natural justice requires that before a law can become operative, it must be promulgated or published. It must be broadcast in some recognizable way. Now, we are talking about 1951. After that, I'll show your lordship the later judgments. I'll show your lordship the later. We are just dealing with it. This is the basic foundation. It must be broadcast in some recognizable way so that all men may know what it is. Or at the very least, there must be some special rule or regulation or customary channel by or through which such knowledge can be acquired with the exercise of due and reasonable diligence. The thought that a decision reached in the secret recesses of a chamber to which the public have no access and to which even their accredited representatives have no access and of which they can normally know nothing can nevertheless affect their lives, liberty, and property by the mere passing of a resolution without anything more is abhorrent to civilized man. It shocks his conscience. In the absence, therefore, of any law, rule, regulation, or custom, we hold that the law cannot come into being in this way. Promulgation or publication of some reasonable sort is essential.
So the manual is published?
It's not published in the because the only publication which is recognized is through the Gazette. I'll show your lordship that. Only no more is publication in the official. They can't show a Gazette notification. And moreover, if your lordship sees, I've read that Calcutta Gas Company. It is not for me. They have to talk. They have to make it. If they want to, they have to talk to the municipality. They have to talk to the state government so that the state government puts it in there, in the act itself. The state government doesn't want to do it. They have nothing to do because it's a state subject. That's why that ancillary, whatever is made ancillary is within that jurisdiction of the state government and no other. Even if it's published in the official gazette, doesn't it? I'll say that is white. That's what the Calcutta Gas Company says. Now, if your lordship can, may I read? Thank you.
Yes.
Now, if your lordship, if I may keep on reading, if I may take some more of your time. In England, the rule is that acts of parliament become law from the first moment of the day on which they receive the royal assent, but royal proclamations only when actually published in the official gazette. They also have that, but even the Halsbury, that's what he says. But even there it was necessary to enact a special act of parliament to enable such proclamations to become law by publication in the gazette. Though a royal proclamation is the highest kind of law, other than an act of parliament known to the British Constitution, and even the publication in the London Gazette will not make it a proclamation valid in Scotland, nor will publication in the Edinburgh Gazette make it valid for England. It is clear, therefore, that the mere enacting or signing of a royal proclamation is not enough. There must be publication before it can become law. And in England, the nature of the publication has to be prescribed by an act of parliament. That's, I was reading paragraph 10, if you look for me. Then after that, paragraph 12. The principle underlying this question has been judicially considered in England, for example, on a somewhat lower plane. It was held in Johnson versus Sargent and Sons that an order of the food controller under the Beans, Peas and Pulse Requisition Order 1917 does not become operative until it is made known to the public, and the difference between an order of that kind and an act of the British Parliament is stressed. The difference is obvious. Acts of British Parliament are publicly enacted. The debates are open to the public, and the acts are passed by the accredited representatives of the people, who in theory can be trusted to see that their constituents know what has been done. They also receive wide publicity in papers and now over the wires. Not so royal proclamations and orders of a food controller and so forth. There must therefore be promulgation and publication in their cases. The mode of publication can vary. What is a good method in one country may not necessarily be the best in another, but reasonable publication of some sort there must be. Now, thereafter, your lordship will kindly come to 13. Nor is the principle peculiar in England. It was applied to France by the Code of Napoleon, the first article of which states that the laws are executory by virtue of the promulgation thereof, and that they shall come into effect for the moment at which their promulgation can have been known. So also it has been applied in India in, for instance, matters arising under Rule 119 of the Defense of India rules. For example, see so and so, so and so, so and so. It is true now after that, it is true none of these cases is analogous to the one before us, but they are only particular applications of a deeper rule that is founded on natural justice. Now here, what is being said is that before promulgation of a rule, your lordship knows, or an act, objections are invited. Thereafter, there is a parliamentary debate, the bill is passed, and then it becomes a law. after the presidential consent. And then after that, if there is anything that make rules under this, so and so, then the rules are, but these are not, manual is never, it's not made under that. It doesn't show an act of the railways, which the manual is a rule. Now, the next one, Millard, about publication part of it.
Yes.
Those are administrative instructions that affect their office. No more. Now, Millard, this one is 2009 SCC 461. 2009 SCC 461. Now, if your lordship kindly comes to paragraph 40.
Yes.
Paragraph 40. From the aforesaid judgment, it can be stated that it is an established practice that the publication in the official gazette, that is, the Gazette of India, Sikh, is an ordinary method of bringing a rule or subordinate legislation to the notice of the persons concerned. Individual service or general notification or even or on every member of the public is not required, and the interested person can acquaint himself with the contents of the notification published in the Gazette. It is the usual mode followed since years, and there is no other mode prescribed under the present statute, except by the amendment in the year 1998 by Bill 21 of 1998. Now, thereafter, if your lordship kindly comes to paragraph 12. In the case of Mayor Hans George, AIR 1965 SC 722, it was contended that the notification under Section 8 of the Foreign Exchange Regulation Act 1947 of the Reserve Bank of India could not be deemed to have been in force and operation merely from the date of issue or publication in the Gazette. It would have effect only from the date on which the person against whom it is sought to be enforced had knowledge of its making. A contention was raised as regards the precise point of time when a piece of delegated legislation like exemption notification by the Reserve Bank would in law take effect. In support of that contention, reliance was placed on the decision of the Privy Council in Lim Chin Ike versus R. The court negatived the said contention by holding that in the first place, the order of the minister dealt with by the Privy Council was never published, since admittedly it was transmitted to the immigration official who kept it with himself. The court observed, now this is what I'm going to show your lordship, kept it with himself, one officer to the other. I'll show your lordship that. The court observed, but in the case on hand, the notification by the Reserve Bank varying the scope of the exemption was admittedly published in the official gazette, the usual mode of publication in India, and it was so published long before the respondent landed in Bombay. The question, therefore, is not whether it was published or not, for in truth it was published, but whether it is necessary that the publication should be proved to have been brought to the knowledge of the accused. Lastly, the order made by the minister in Singapore, in the Singapore case, was one with respect to a single individual and not a general order. Whereas we have before us is a general rule applicable to every person who passes through India. In the first case, it would be reasonable to expect that the proper method of acquainting a person with an order which he is directed to obey is to serve it on him or so publish it that he would certainly know of it, but there would be no question of individual service of a general notification on every member of the public. And all the subordinate lawmaking body can or need to do would be to publish it in such manner that persons can, if they are interested, acquaint themselves with its contents. Thereafter, my lord, if your lordship kindly comes to 13, paragraph 30. The court referred to the judgments of validity K in Johnson was sergeant. Lordships got it.
Yes.
And did not approve the observation made therein to the effect that the order was not known until the morning of May 17, but it came into operation before it was made known. On the contrary, the court held that there was great force in the learned author C.K. Allen following comment on the reasoning in Sergeant's case. This is a bold example of judgment law. There was no precedent for it, and indeed a decision, Jones, which, though not at all not on all fours, militated strongly against the judge's conclusion, was not cited, nor did the judge attempt to define how and when delegated legislation became known. Both arguments and judgments are very brief. The decision has always been regarded as very doubtful, but it never came under review by a higher court. The court also held that it is obvious that for an Indian law to operate and be effective in the territory where it operates, viz., the territory of India, it is not necessary that it should either be published or made known outside the country. Even if, therefore, the view enunciated by Balice is taken to be correct, it would be apparent that the test to find out effective publication would be in India, not outside. This is a case where somebody was coming from outside and he had some money or gold, and he didn't know. But this Gazette notification, there was this Gazette within the Indian territory as land, the supposed to have that notification. Now, unless a Gazette notification is there, it does not take. So, law. There is now, if your lordship time comes to the, I think this is so right now. This is Dwarkanath Tiwari, 1958 SEC, AIR 1959, AIR 1959, SC 249. So this is a case where the Bihar court was published, but there were certain things which were not published. And under that, a school run by the trustees was sought to be taken over by the Bihar government. Now, this is what happens. This is what the court says, that this is not law. What is law? And that is very important to us. As already Miller kindly comes to paragraph 12.
Paragraph
12.
12. As already indicated, proceeding on the assumption that the land and the building are vested in the petitioners as managing committee of the school, have the petitioners been divested of their rights by authority of law under Article 31(1) of the Constitution? If the amended Article 182 of the code extracted above is law within the meaning of the article aforesaid of the Constitution, the petitioners cannot have any just complaint if they have been or are being deprived of those properties, because it is clear that the petitioners are holding the properties not in their individual absolute rights, but only as trustees for the purposes of the school. They have the properties vested in them because they are the managing committee. If they have been divested of those rights by the authority of law, this petition under Article 32 of the Constitution must stand dismissed. If, on the other hand, the amended Article 182 of the Education Code is not law within the meaning of Article 13 of the Constitution, then the petitioners cannot be deprived of their right to hold the properties as trustees by a mere fiat of the officials of the government of Bihar. Though in the affidavit sworn on behalf of the respondents, it was claimed that the provisions of the Bihar Education Code had the force of law, it has been conceded by the learned Solicitor General appearing on behalf of the respondents that he could not justify that contention. The preface, the latest edition, 7th edition, printed in 1957, the Bihar Education Code, 1944, contains the following statement by the then Director of Public Instruction, Bihar. The Bihar Education Code is compiled in the office of the Director of Public Instruction, Bihar, and is issued under his authority.
those articles below which no reference to a higher authority is cited as the same authority as circular and other orders of the director. Now thereafter, paragraph 30. It is, your worship's word, paragraph 30. It is clear, therefore, that the portion of the preface extracted above, that Article 182 of the Code has no greater sanction than an administrative order or rule, and is not based on any statutory authority or other authority which could give it the force of law. Naturally, therefore, the learned Solicitor General, with his usual fairness, conceded that the article relied upon by the respondents as having the force of law has no such force, and could not, therefore, deprive the petitioners of their rights in the properties of force. So if this was to be used against me, it has to have the force of law, otherwise I cannot be deprived of my right. In fact, they are depriving me of the right to develop it. It must be a very strong case. Now, if your lordship kindly comes. Section 23 of the General Clauses Act. The last conclusive proof. Obligation is conclusive proof. Nothing has been shown about obligation here. And we go by the affidavit of it and cite it. The last one, publication.
Yes. Yes.
So the publication is absolutely essential for a law to be brought in force and for its enforcement before a court. And if your lordship is the not possession. I've shown your lordship. Does not lie. Now, if your lordship kindly takes a second writ petition that is nine one zero three, Prashantu Undit and others.
Yes. Yes.
Page 47. This is what is being relied on. If your lordship sees Government of India, Ministry of Railways, Railway Board. So, what was argued in the first writ petition that the railways is a local authority, and there was a judgment placed before your lordship that local authorities should be consulted. So that was the judgment. Railways is not a local authority; it is another authority under Article 12, because it's under the Ministry of Railways. If your lordship sees this. Now, if your lordship kindly comes to this particular notification, there's a number given, New Delhi, so and so. This is a manual, extract from a manual. General Manager, all zonal railways. Whom is it addressed to? This is to the general manager. An administrative instruction. Not to me, not to the public. And who's giving this? To Principal Chief Engineer, all zonal railways. So internal communication between two officers for their guidance. Is it sacrosanct? Is it the law? I've shown your lordship that this is not enforced. Is there anything, any gazette notification? No. Just a letter, just a direction. Now, if your lordship kindly sees, even they are also alive to the fact that they might be encroaching on the rights to property, means under Article 300A of others, that they might have to acquire. That's what I'm going to read before you. They're not sure themselves because they know that they can't do it. The construction of government and private buildings near the railway land is governed by paragraph 827 of the Indian Railways Works Manual IRWM. The basic intention behind the stipulations of the paragraph is to safeguard paragraph, not rule or regulation or anything, is to safeguard railway interests in such a manner that no future encroachments take place. And there is no accrual of easement right, such as right of way. What he was saying is absolutely different. They want to safeguard their own property, the railways, and no further. That people should not encroach. They're not talking about my property. Your lordship sees this. This is an internal thing that they've built, because if your lordship sees everywhere, if your lordship goes to Bellyrace road and all that, they are next to the railway line. Buildings have come up, shanties, so they don't want this. This is why this is being. Right to discharge tonnage and storm water, etc., on railway land over a period of time. Everything has an intention. I don't blame the railway authority. In fact, I'm with them. But we should not build near the railway. Now, but what do they want to protect? They want to protect their own land, not anything else. Right to discharge tonnage and storm water, etc., on the railway land over a period of time. Although it has been mentioned that an open space of approximately, by the way, it has been mentioned that an open space of approximately 30 meters between the railway land boundary and the nearest edge of the building, the exact space to be left being governed by the local conditions, be suffice. It is also stipulated that in cities and towns where land is available, valuable, it is not expected of the landowner of a plot to leave a large vacant space between his building and the railway boundary. And it is deemed that the railway interest will be adequately safeguarded if sufficient vacant space is left so as to ensure development of any future road access and drainage outside the railway land, and to avoid requests to surrender railway land to such facility at future date. The duties and the role of railway officials regarding dealing with utilization of land as adjoining the railway land boundary have been clearly defined in paragraph 827 of IRWM 2000. Railways NOC is required for construction of building within 30 meters from railway boundary as per paragraph 827 IRWM. Instruction. With regard to issue of no objection, a certificate NOC for construction, redevelopment of government and private land on land adjoining railway boundary have been issued with the above referred letters. No rule, no law. Letters. It is observed that railways are following different procedure, and on some zonal railways, too much time is taken in granting NOC. Hence, the need is felt to streamline the procedure. The party be asked to submit the following documents along with request letter duly forwarded by state government, local authority to the concerned divisional office. Now, therefore, if your lordship sees there is nothing here, and they know it very well. They have not put that in the act. They have not requested the state government, nor the municipality, to promulgate a law, putting some provision to take. Nothing, just a letter. And that is touted to have the force of law before a big court. These are all guidelines for their own internal. It's got no binding effect on me. Nothing. They have to show that. And they have not been able to show it. Because this is complete. No gazette notification, nothing.
Yes.
No railway rule has been cited. Only the manual and paragraphs and a letter. This is what now, if your lordship kindly comes to 9, that is page 49. Page 49, 9, paragraph 9. As regards compliance of provisions of development control regulations or other rules issued by state government, local authorities in this regard, it is for the state government, local authorities to examine and ensure compliance of the same. The provisions of IRWM are not meant to unnecessarily restrict the utilization of the land adjoining railway land on the plea that such land may be required for future development of the railway system. As I said, Miller, they have to acquire it. And in case land is required by the railways at a future date, it is only fair that the same is required after paying due compensation for the land and the built-up property.
Yes.
So they are alive to this fact, but they can't do it. What we've said is that we've violated 217. Section 217 has been violated because we've suppressed fact. We didn't even know. And they also say that, no. Well, it's only to protect ourselves. They are alive to the fact. And therefore, Millard, now we come. If your lordship kindly comes, which I read in the report, your lordship sees this report. Very now there's, as I said, there's a absolutely a concert being played, and somebody is in the railway amongst these writ petitioners. I can tell your lordship that. Look at the alacrity, the flamboyance, how fast they act, and we know that if your lordship is not taking if your lordship cancels a ticket, it takes at least 1 year for the money to come back. And look at this. During the hearing, your lordship kindly comes to page 4.
Yes.
This is to inform you regarding the under construction multi-story building by your company beside HWH, means Howrah, Bardhaman, main line near SRP station, that since the construction of the building is being carried out at a distance of 2.20 meter from the adjacent railway boundary, as per railway guidelines, NOC should be obtained for construction of any building within a distance of 30 meters from railway boundary. As no NOC has been obtained for construction of the above said property, therefore it is being advised to stop the work till proper NOC is being obtained from the competent authority. Now, if your lordship sees, as per railway guidelines.
Where it is? Yes.
It's just the first paragraph, 2 lines from the 2 lines, the second line from the bottom. As per railway guideline. No rule, no act. And he assumes this jurisdiction. I don't know from where he gets this jurisdiction, because a jurisdiction must be conferred by the act or the rule. He's Yes, senior section engineer. From where does he get it? He might have got it from page 47, which I showed you from the manual. But he doesn't get anything. There's no delegation of power under any act or rule.
Yes.
And as your lordship sees the malafide, 18/12/2024, your lordship was hearing this matter. Your lordship was hearing this matter. And your lordship had directed, okay, give me a report. Nothing more. Your lordship never asked him to pass this order. If anything, it is a contempt. He not only exceeds his jurisdiction, he exceeds even the jurisdiction that's granted to him by the court. Hearing. My plan was sanctioned in 2018, and the building is absolutely constructed. They come up before this court in 2023 with a writ petition, but I refuse to negotiate. 20. I'll take that point of locus also later. I'll take that point. And I'll show you, lordship, that the building rules, I have left specific gaps, and they are not prejudice. The standpoint is prejudice. Now, if your lordship kindly comes against this report, exception and
Yes.
Now, against this report, I have filed an exception.
Yes.
It's only the third paragraph that I want to place before you, lordship.
Yes.
The statement states paragraph 4 is denied and disputed, and I say that there is no law or statutory provision for obtaining no objection certificate from the railways who are not the owner of my property. The impugned order passed by the senior section engineer dated 18/11/2024 is not only malafide but without jurisdiction. Nowhere does the Railway Act or rule empower him to issue such an order. That the said officer, along with some railway staff, are hand in glove with the writ petitioner is apparent from the fact that during the pendency of the hearing of the writ petitioner, in fact, the writ petition is being heard, the officer who has no business in the matter and not having been empowered to issue such order has become interest in the case of the petitioner and issues an illegal order. The law does not permit the railways to prevent us from building on our land, since the land is not acquired by the railway. In fact, the officer discriminates in that the petitioner's house, now this is very important also, is about 3 feet from the railway line. And yet the officer connives with the writ petitioner to abuse his powers and pass an illegal order. Now, if your lordship kindly comes to the next, that's a proof.
No, what does this say? In fact, the officer discriminates in that.
Yes.
You are reading?
Your lordship kindly sees that photograph.
2.2 is 3 feet.
3 feet. 2.2 meters is 6 feet. Just
So-
3 feet, the gap. Then he comes seeking equity. Comes to enforce his rights. Does he come with clean hands? No, brother. He doesn't. And
Okay,
he
just,
doesn't take any note. The operator doesn't take any note.
Okay, what we have submitted, it is left to the parties that how much space is to be left, or is there any rules under the Municipality Act?
Next day, I'll address you.
Because safety and security is a concern.
But not the railways, they can't. Safe because of the fact that they're the letter itself, which I might say, that letter itself says that, please, our land should not be encroached. That's the defense mechanism. They want that, no, they shouldn't. Because your lordship has seen shanties, people making illegal constructions. That should be stopped. But I agree. I totally agree. But they should come up with a law. They can't just. But here, of course, this is my owned land. Owned. O-W-N-E-D. Owned land. So if you have to put restrictions, you either acquire it for your purpose. Otherwise, restrictions are going to be very, very, very. Because it will militate against my rights of ownership. And that is one of the highest rights recognized. But, the next day I'll be addressing your lordship on the other aspects which were taken up. As fallen from your lordship, as to whether there are proofs that we should keep.
Let him come to. Mr. Chakraborty, since the letter which has been indicated by Mr. Sannal that it says paragraph number such and such, you produce that manual. I have a look to that manual. The railways manual which has been indicated in the letter. You just produce that manual. Or Mr. Exception to the report. Heard Mr. Sudeep Sannal and its senior advocate appearing for the private respond numbers 8 to 11. 8 to 11.
8 to 10.
Huh?
8 to 10 and 8.
Oh.
One is 8 to 10, one is 8 to 10.
দেখে নেবেন ঠিক আছে হারটা কেটে দিন Mr. Sudeep Sannal places his points of arguments. He seeks some accommodation to place his further arguments. Release this matter on ফাঁকা দেখি 16th. Oh, take this book back. And congratulations, Mr. Sannal. এটা আমাদের না ওনার বই
law points are to be answered. One chance.
Let him first complete.
Yes, yes. After his completion.
Yes. কোনটা বলুন তো আর 6 এখন কখন নেবে 6টা কালকে নট টুডে কর 6 এ কে আছে
6 এর তো
Morning, I could not able to appear to a lot of the matter going on. So please do pass the matter over for time. Which is almost, but let us be taken up more.
Yes.
My lord,
Well.
maybe next week.
আচ্ছা ওরা কি ওতে রিপোর্ট দিয়েছে
Yes, yes.
Report already submitted, recorded, please.
আসুন তো item number 6 joint survey report
Item number 6.
submitted by the state respondents as well as Union of India in terms of order of this court is taken on record. Copy you have given?
I did have everything, but the internal thing that
You give a copy? Copy served. Let this matter, Friday তে দেখুন। Friday বা অন্য একটা দিনে।
Friday মানে 6
6th আসবে? 6th on Friday. Release this matter on 6th December. Where is the parties?
much of it.
My lord, I have served upon all of them. My learned colleague appointed as the commissioner.
No, who is for the private respondent?
I have served, my lord, Parthapratim Rai.
Next Friday.
Parthapratim as well as his junior also, I have served Sandeepan Banerjee also served and also he has served.
কালকে টু মেনশন রেখে দিন তো। Where is he? Where is Mr. Banerjee? And Mr. Who is for the private respondents?
Parthapratim Rai and Mr.
Dutiman Banerjee. They have not come.
Devan. Hello, Devan.
কালকে থেকে to be mentioned এ
I
রাখুন।
also rang him. He told me I am not in the court. You kindly keep it on any other day and it has to be mentioned.
কালকে to be mentioned এ রেখে দিন। অর্ডারটা রেকর্ড ছিল কালকে to be mentioned। But keep in mind that somebody has to inspect that. Whatever be the fees, I don't know if they are not in a position.
Anybody, my lord, you can lordship can appoint as per your lordship.
You be present tomorrow. Matter will be taken up to be mentioned. এই ফাইলটা আমার কাছে আছে, এটা নিয়ে কালকে to be mentioned দেব। এখন অর্ডারটা পাস করছি না, ওটা কালকে এসে। থ্যাংক ইউ স্যার।
Any mentioning in the bench?
Yeah, may I be permitted to mention, Lordship, this is item number 69 to 71 of the monthly list, Lordship. Actually, the interim order is expiring today. In case the Lordship doesn't take up the matter today, Lordship may list the matter tomorrow under to be mentioned.
Maybe monthly list. লিস্টটা কোথায় এটা ও আজকে তো ফার্স্ট ডিনার কবে যাচ্ছিল 69 to 71
69 to 71.
আজকে কি সাপ্লিমেন্টারি করে দেবেন নো ডেলি লিস্ট আছে কবে এটা ইয়ে করল which is the order of this extension last extension
Last order, Lordship, 12th November.
exact দেখাচ্ছে জি
69 to 71.
interim order is passed in only one item, that is
Yes, J16, Lordship.
আসুন Miss Swen Sulan, advocate, 71 in a monthly list.
For the respondent, my lord.
Or the applicant seeks for extension of the interim order granted earlier on 15 December 2023. In view of such submissions, the interim order granted earlier on 15 December 2023 is extended till for a period of 4 weeks. 4 weeks হলে আমরা এসে যাব 6th January. নোট দিচ্ছি না যে লিস্ট এখানে থাকবে ম্যাটার
My lord, with regard to item number 14, with regard to item number 14, the dependent number 1 has been directed to file the affidavit in opposition. But the affidavit in opposition has not been filed, but it has been ready, but cannot be affirmed due to the illness of the dependent number 1. My lord, I need some time. My lord.
Let it be in the list. We'll see.
I'm only opposing this one because first of all, my your lordship had directed, they have not given that. 1 week after that order, there's several weeks have gone now. After that, my lord, the applicant has also requested your lordship that the suit may be disposed of as expeditiously as possible. Now, my lord, my learned friend is going to take time. My lord, I think he needs to be put on terms, my lord, and give because he's already out of time.
ঠিক আছে
I'm grateful. I was not aware that he's going to mention. That's why I just.
My lord, may I have your lordship to my lord, today the time to file AO has expired. My lord, they have not served us. They've had 10 weeks.
item number
My lord, it is out of the list. It is due to appear next Monday. No AO has been filed. My lord,
let it appear
my lord, let it be fixed day after tomorrow under adjourned
no.
motion.
Let it appear when the matter is going to appear.
My lord, next week.
Let it appear next week. We'll see. Doc.
Monthly list of December, item number 1.
The plaintiff's for the plaintiff.
On the last occasion, directly. is had also can be re-deposited. May I subject to indicating the compliance of the order.
Okay. File it.
And I'm submitting.
Account has been opened.
Yes. And now I'm taking out my picture. But although it is not recorded in the order, but observation in both settlement, I cannot allow you again open the account and get the entire amount deposited. Now this has been complied with. Can you come to page 20, my lord?
Who is for the plaintiff?
I'm for the plaintiff.
Yes.
Lord,
May I? Lordship, after this order, your lordship, the parties have sat together to come out with some solution about the sued property, your lordship. And I think what has been instructed to me is to seek 4 weeks' time so that we come back with a settlement, your lordship. I've been instructed so, but I think my learned friend will agree, my plaintiffs will agree to that.
Both the on the prayer of learned receiver, leave is granted to file supplementary affidavit. Supplementary affidavit filed by next line. Supplementary affidavit filed by learned receiver is taken on record. Mr. Devanand Misra, learned advocate receiver, informs the court that pursuant to order of this court, the trust bank account has already been opened with the Standard Chartered Bank, 6 Church Lane, Kolkata. He seeks for his discharge. Both the learned advocates for plaintiff's number.
I'm for the plaintiff number. All the plaintiffs.
How come all the plaintiffs? 1A.
All the the power is with
For all
yes, all the
plaintiffs, for plaintiffs as well as defendant numbers 2B, 2C, and 2D submits that a talk of settlement is going on and they seek for 4 weeks accommodations. Is this matter in the monthly list of January 2025. The prayer for discharge of the receiver will be considered on the next date. No, not now.
Before the observation made by your lordship.
Not now.
Lordship, can you record that the supplementary affidavit has been circulated?
The supplementary, supplementary affidavit file copy has been served upon the plaintiffs as well as the answering defendants.
No, my lordship knows the role of the receiver. Lordship has understand that Charishila matter. I do not want to continue further. This is never done. I do not want.
If suppose I tell you one thing, if it continues and there is a dispute, I will appoint a separate receiver. Since the matter is going to be settled, now you are holding. On the next day, we'll decide. I have indicated in the order. Yes, I have indicated in the order. Your prayer for discharge is not considered this day, but it will be considered later on.
But I am not required to personally subject my lordship.
If required, I will ask you.
Item number 2.
My lord, 2 and 3, my lord, are connected matters. My lord, in my suit is item number 3. My lord, in both the suits together by a common order, my lord, a special officer has been appointed, referee. My lord, before whom, my lord, reference is continuing on a day-to-day basis. My lord, I am told that the arguments are being advanced before him. My lord, therefore, my lord, some more time is required by both the parties to bring the reference to an end. My lord will kindly keep the matter in the monthly list of reference. My lord,
Since the time till end of January, we will file the
February, my lord. So they can complete and
we can come back in sometime in February.
Oh.
last order touch. Last order.
Commission
তাতে কিছুই নেই অর্ডারটা হচ্ছে 23rd
on the
my lord the order dated 23rd March 2023 my lord that is the order by which the special referee was
again 23rd March. You have the copy of the order? Oh, Haj. This appointment is officer to carry out the content in order.
my lord will kindly take the last page. Put the middle of the paragraph, main paragraph there. Mr. Such and such advocate who has been already appointed as a special referee will carry out the direction.
When the advocates representing the respective parties seeks for extension of time, it informs the court that the proceedings before the special officer in terms of order of this court is being carried out. However, the same has not been concluded as yet. They seek for extension of time. These matters, it was just 2 and 3, no?
Yes.
3 and 4.
My lord, 2 and 3.
2 and 3. Is this matter in the monthly list of January? Okay, February.
January will give us only till December.
Yes.
My lord will kindly give time till
February.
Keep it up.
Monthly list of February. 20.
What is, my lord, my request would be till the end of February.
Till
My
the
lord.
end of February, kindly exercise the time because
Yes.
my lord, I submit one thing, the other side's advocate who is appearing, Mr. Procedural, he has suffered a period. So the proceedings have to be adjourned. That is fine.
The March list chale jabe.
Yes, great.
March monthly list.
My lord, till the monthly list of the monthly list.
March.
My lord has extended till very.
Item number 4.
For the KMD in this my petition will not.
Sir, one application was filed by my client, year 9 of 2020.
You disposed of?
No, my lord, only one thing I may just indicate. Now, my lord, only one problem, my lord, is that, my lord, this writ petition was heard at length, my lord, by a bench, by a coordinate bench. My lord, at that juncture, my lord, an application for addition of party was filed. Now, my lord, that addition of party application was disposed of, my lord, with an observation that the issue involved in the writ petition, my lord, is nowhere connected with the subsequent or recurring application for addition of party, which is coming up before this court, and my lord, the hearing is being stalled. Now, what is happening is, my lord, the writ petition has been filed, my lord, challenging, my lord, an acquisition process by the state. Now, my lord, this application for addition of party, which are subsequently coming up, my lord, is challenging to the title, claiming that we are the owner of that. My lord, the issue when is whether the acquisition is right or wrong. My lord, whether he is landowner or my lord, me as a landowner, this dispute between two of us as to the title can be, my lord, sorted out in a suit court. This has nothing to do with this in the writ petition. So, my humble submission is, let this writ petition be fixed for hearing. along with that application of addition of party be heard together. My lord, this segregation, my lord, is making a difficult. My lord, kindly takes up, my lord, the previous order by which the earlier application for addition of party was disposed of. Kindly takes up, my lord, order dated 17 November 2023.
17 November.
Well, at that time, GA8 was taken up. This was an application for addition of party. Party এসেছিল নামটা now my lord, paragraph 6 of that order, my lord, will find they are claiming title over the subject land. My lord, will find the paragraph 6 of that order. My lord, same thing. Another set of parties are coming up with this application. He will lose. My lord, another set will come. So, my lord, the hearing, my lord, since 2008 is kept pending.
My lord, may I give the audience? Lord, please, the petitioner file this application. Lord. The land belongs to my petitioner. That's acquired by the state of West Bengal. And Lord, I annex all the documents. And after that, now the body. And to return back the land, excess land after return the project to the harbor. And Lord, that is why, Lord, I have the right to return, to get back that property by payment of unit fees. That is why, Lord, kindly allow me to contest this petition because, Lord, the property belongs to my predecessor in interest. After acquisition, my predecessor interest, got the compensation also. And Lord, I annex the, kindly have it, take one. Lord, GA9, Lord, I annex those documents.
Din GA.
Page 9, Lord, kindly have it.
GA9.
GA9 is not tagged.
তাহলে কি করবো নট করে দাও আচ্ছা ও তাহলে না অর্ডার করে 3 দিন পরেই রাখি মেনশন আর অর্ডার করছি না আর নাহলে আপনার কথা বলতে হবে যে বিফোর স্যার GA has not been issued, department directed to place. It is informed by the court officer that GA 9 of 2024. This is your application GA9
GA9 of 2024.
for addition of party have not been received. Department is directed to place GA9 of 2024 positively on the returnable date. Release this matter on 6th December. 6th under the same heading.
My lord is only tagging. My lord is tagging the GA. My lord, on 6 days, same heading to be mentioned. My lord, I was apprehending if my lord fixes it for hearing of the writ petition.
No. Let the GA come because the GA is not here. I see what is his ground. Thereafter, I will decide.
Lord, in place of 6, Lord, it is 7th or 8th.
7th Saturday. Will come.
But I think another GA is pending. GA8 is also pending.
No, GA disposed of. This order to the 17th now. 8 to 17.
8 disposed of.
Disposed of.
In place of 6.
Over there, 9th.
Only one thing, Lord, 9th in the first half, Lord, can it be taken up? Very good.
7th Saturday.
Let it be 9th, Lord, 7th.
7th Saturday.
Item number 5.
The orders dated October 7, 2024 and September 2, 2024.
Is appearing for the defendant? Who is for the defendant? You have given notice?
The defendant lordship has recorded in the last order of October 7th that they are not appearing despite service. They had been appearing, but
why it is listed under to be mentioned?
We mentioned because lordship would find from the order dated September 2, 2024, it was pointed out by us that probably this suit should be heard in the commercial division. And 2nd September, 7th October, 8th. May I, my lord, please. There are other orders in between, but
Going to submit there is a suit, CS number this and these are of nature of commercials and for such and these suits are to be converted suits under the also indicates that no separate application for such conversions. And it is a material on 18 September. Hold on. 7. Withdraw this suit. Given that on the previous applicant, such written instruction received from 20 was also furnished in court. From supporting procedural this court. Okay. One has been withdrawn by you. The other suit has to be listed under the commercial. What is the matter? Is it CS rated in the? Why it is coming under commercial?
Yes, the reliefs at page 12. Reliefs at page 12. Decree for recovery of vacant and peaceful possession of the demised premises fully described in schedule, then in profit transfer. Now, lordship would kindly see the cause of action at page 8. Page 8, the continuing paragraph, the first full sentence of page 8. Yet the defendant was never authorized or empowered to make any construction by way of any construction, and that paragraph 8. So, my lord, what you really ask for is forfeiture, the ground of 108p, and my lord, the contractual clauses. Now, if lordship kindly turns to yes, page 3. Page 3. Paragraph 3. The defendant at all material times used to carry on his business from the state granted premises. Now, this is, my lord, lordship would find that the lease is dated May 1998 for a period of 30 years. And from the lordship would find that now it's Henry Youth. It used to be Hippolyte Printing Company, the original, as it was originally added. Now, my lord, they run a printing press from there. Now, so this is, my lord, commercial usage, there is no doubt. And, my lord, it arises, my lord, out of a dispute, out of, my lord, this lease deed. That's why, my lord, we say, lordship would kindly come.
Transaction version.
Now, lordship would kindly consider the Commercial Codes Act, section 2C. Commercial, may I place, my lord? Commercial dispute means a dispute arising out of, now lordship would kindly consider subclause 7. Agreements relating to immovable property used exclusively in trade or commerce. Now here, my lord, this relates to immovable property used exclusively in trade or commerce and arises out of that agreement, the dispute. And Lordship would also find that in the explanation, immediately after the subclause 22, explanation, a commercial dispute shall not be a commercial dispute which will involve action for recovery of equal property or for realization of money or just because it's equal property, my lord, there is no bar. Now, my lord, Lordship knows for my satisfaction, may I, my lord, place
For
yes. But you would kindly consider page 13 at paragraph 22. Page 13, my lord, paragraph 22. Time and place. Paragraph 22. Here it says the commercial disputes may also involve action for recovery of intellectual property or for realization of money or for intellectual property given a signature involved any other relation party to intellectual property. The explanation of section 213 purpose takes place that a dispute otherwise a commercial dispute as defined under section 213 shall not cease to a commercial dispute because it involves a commercial dispute and not otherwise.
okay,
I feel that
this matter is appearing under the heading to be mentioned. Mr. Swenso, learned advocate, appearing for the plaintiff, submits that the relief sought for pertains to commercial relief sought for in the suit pertains to commercial dispute. As such, the suit should be converted to a suit under the commercial division in terms of section 2C within bracket 7, Roman 7. Of the Commercial Courts Act 2015. To buttress his contention, he relies on the decision of this court passed in India Media Services Private Limited, APOT. In this suit, the defendant appeared.
yes. Defendant appeared, filed written statement. They have been continuously opposing our interlocutory applications.
Okay.
But the last 1 year or so after the name was changed, the defendant.
This notice has been given to the defendant.
Yes. Lordship's previous orders record that the defendant, their learned advocate.
Oh, you have given notice of both the suits.
Yes.
No. Despite service of notice, none appears on behalf of the defendants. This is a suit for eviction and for realization of money. This prayer B is for realization of which amount? This is rent due.
Lordship would find in paragraph 14.
For realization
of 13, if Lordship kindly turns to paragraph 13, we say that the from 1st April 2009, mean profit at the rate of so and so. That is, my lord, the next page from 1st April
7th April.
2009 to April 7th.
For the realization of mean profit. 17 and for outstanding rent due.
Yeah, my lord, the appointed report. This is the affidavit of service.
Affidavit of service.
Yes, from the company it has been served, as also the learned advocate.
ওপরে একদম টপে দিয়ে দিন affidavit of service filed on behalf of the plaintiff is taken on record. ওপরে চলে upon going through the averments in the plaint, it appears that the defendant at all material point of time used to carry on its business from the tenanted premises. Considering the above, in view of section 2C of the Commercial Codes Act, the suit would be converted to a suit under the commercial division. As per section 15 of the Commercial Codes Act 2015. Department is directed to take necessary steps in this regard. What is the stage of the suit would be?
My lord, discovery and inspection is yet.
Okay. Let the matter go out of list with liberty to mention. After the allotment of number is there, you mention, then we'll. Any.
Item number 6.
I'm very reports now the last time the reports come, then we will be hearing date will be fixed. So we will be prefer hearing date.
Matter is appearing under the heading.
January.
We mentioned.
Same side.
Okay, both of you are on the same side.
Yes. Number 5. Respondent number 5.
Readings are complete.
Yes, readings are.
My lord, I appear, my lord, for the respondent number 6, 8, and 10. My lord, we have the affidavit in opposition ready, my lord. Before the date of the hearing, we'll be serving our copy of the opposition, my lord, to my learned friend. It's affirmed, my lord. It was affirmed quite some time back, my lord. For some reason, because of old matter, it couldn't be served. My lord, we will be serving our copy of our affidavit, my lord, upon the petitioner. And file it before this court, my lord, much before the returnable date.
My lord, only thing we have affirmed a reply against the opposition filed by this so many respondents, 1, 2, 3, 4, 5, 6, 7, 10, and respondent number 8, 5 affidavit in reply. May we file this reply?
But then I think they have not yet filed the affidavit in opposition.
My affidavit in opposition is on record. I have filed it. This one number 5 opposition is on record.
Okay, which of the oppositions have been filed? Against that you file your reply. Which has not been filed as yet?
May I suggest this?
You are appearing for respond number 6, 8, and 10.
Yes, 6, 8, and 10.
6, 8, and 10. Accepting 6, 8, and 10, you are representing 5. Madam? Okay. Affidavit. Yes.
We'll file those replies accepting 6, 8, and 10.
Okay. Mr. Shatudi Bhattacharya, learned advocate,
yes,
appearing
For respondent number 6, 8, and 10, my lord.
6, 8, and
Yes.
10 through
Yes.
virtual mode. Is the affidavit in opposition affirmed within the time as stipulated
My
by
lord,
the
it was affirmed long back, my lord. I'm told quite some time back, and in fact, I've also been told it has been served upon the petition. My lord, that's my instruction I have received, but it has not been filed.
to file affidavit in opposition? Let such affidavit in opposition be filed within a week.
Yes, within a week.
আচ্ছা, affidavit in reply ওটা gap দিয়ে রাখুন. You just indicate against which you are filing. Affidavit in reply filed by the petitioners against the affidavit in opposition of respondent numbers 1, 2,
1, 2, 3, 4. 1 and 2, 1. 3 and 4, 1. 1, 2, 5.
1, 2, 5
And 7.
and
4
7
affidavits.
and
For
7.
reply.
Accepting respondent number 6, 8, and 10 is taken on record. List this matter. আচ্ছা, ঠিক আছে, 13 January.
Grateful, my lord, deeply obliged.
Item number 7.
Lord, I appear for the defendant respondent.
Is coming up after service, Madam, with an eviction suit. Hey, the sole defendant, it will come back to your lordship, Madam, the sole defendant was the sole proprietor of a firm against whom the eviction suit was filed. Now, Madam, during the pendency of the suit here, my learned friend's client, Madam, I understand he's appearing for Elon Saha. Because he
Hearing
was
for the partnership firm, Lord, I was only humbly praying this, Lord, I don't think Mr. Lord Thakkar has a scope for an interim order today. So, my lord, I can file an affidavit because, my lord, this suit, I have got an order from the department itself, was dismissed by an order dated, my lord, 6th of December 1995. And, my lord, I don't find any restoration, my lord, story in the entire pleadings. So, my lord, be that as it may, my lord, I don't think there is a interim order that he is seeking for in terms of the reliefs that he has sought for. So, my lord, I can file an affidavit and we can come back, my lord.
subject. I don't think Mr. Banerjee will oppose, perhaps, order in terms of prayers B and C. Death of Joy Krishna Saha be recorded. That perhaps he cannot oppose, which is prayer C, my lord. An abatement, if any, on the death of Joy Krishna Saha be set aside. This perhaps he will not come in the way, then he'll file his affidavit, the matter can be heard out, my lord. He is then
My lord, all that I am saying, my lord, I would have not opposed B and C in the usual course. Thakkar knows it, but my lord, this order of Justice Ajit Kumar Sengupta, my lord, of the dismissal of the suit, once it is dismissed, my lord, unless my learned friend shows a restoration, my lord, B and C lordship will not have jurisdiction to pass as on today.
Awesome.
That is the only issue, my lord.
Sure.
Lordship will
Shoturu.
kindly see the plaint once, please.
No, no.
If it is in your lordship's
Let him
record.
come up with the opposition. We'll see what is
No, no,
the
my lord,
effect
the
impact
suit
of that order.
restored. My learned friend is showing a prior order, my lord. If the suit was restored, the application would not have been filed.
Where is that order then?
1995 order.
Kindly see the plaint. If there is an endorsement on the plaint, kindly have the plaint once, please, my lord. This is the application perhaps your lordship is seeing. Plaint asheni? Plaint to nahi hai.
It's a 69 plate and dismissal is of 95, my lord.
Page, kindly have, my lord.
Page?
Kindly have my application once, please, which has the certified copy of the plaint. Kindly come to page 36. Kindly have page 36, my lord, which is a certified copy of the plaint. Kindly see the order of dismissal which Mr. Banerjee is referring to is there. Lordship, A.K. Sengupta, 6 December 1985 dismissed. And then your Lordship sees the towards the after where it is written, restored 23rd December 1985. The judge's file is recorded there, my lord, 23rd December 1985.
This restoration is not upon notice to me. I am the only defendant respondent.
Lord, Dhillon Kumar Saha was not in existence at that time. The suit was defended by the sole proprietor, Ramendra Saha.
I was still a my lord partner then.
It was never a partnership firm. Today, my lord, the suit is in the list. Your lordship's list, the computer records show the suit is
But I
alive.
don't find that there is any scope for an interim order. I don't understand, my lord, if I file my lord, the affidavit with
এটা কি কোথায় দেখাচ্ছে?
Lord,
ঠাক্করকে কোন জায়গায় দেখাচ্ছে? সুর
I just
this one, take this.
Restored.
অর্ডারটা কি করে পাবো?
এই অর্ডারটা
This is the certified copy of the plaint, my lord, which we've taken from the department.
অর্ডারটা তো থাকবে।
The suit has been dismissed, my
order
lord, it
to
would
have-
not have appeared in the CIS.
আচ্ছা। ঠিক আছে, সুটের কি কাগজ এসছে?
Sure, my lord, my Mr. Banerjee does not want to file an affidavit in a dismissed suit. He doesn't want to file an affidavit.
That's what I'm saying. That's what I'm saying. Otherwise, I wouldn't have opposed the press. Otherwise, he would have accepted the press.
কাগজটা নিয়ে চলে আসবেন, বুঝলেন? সুটের কাগজটা প্রেজেন্ট করুন, অপোজিশনটা নিয়ে আসবে, ওই দিনে সুটের কাগজটাও নিয়ে আসুন। দেখ
Grateful.
Mr. Shatoru Banerjee, learned advocate, appearing for
Only defendant response.
appearing for Joy Krishna Saha. No, what is
Dhillon Kumar Saha.
Dhillon Kumar Saha seeks to file affidavit in opposition to the application. Let such affidavit in opposition be filed within a period of 2 weeks. Reply, Mr. Thakkar.
1 week, please, my lord.
Within a week. List this matter. Onion Babu.
Can you give the date for monthly list, my lord?
You mentioned we'll take it out. If it is the pleadings are completed, then
Please.
Yes, grateful. Deep to
Peter, Onion Babu. Which one?
This great.
I'm so sorry, my lord. May the affidavit of service be kept on record.
Affidavit of service over the
Grateful. I'm so sorry.
Item number 8.
My application, Malad, the probate was granted in the name of Shamal Kumar Mukherjee. Shamal Kumar Mukherjee died. For recording the death of Shamal Kumar. And in wife's name, daughter's name, and son name may be recorded. That is my place. Rare EMI.
Where is the grant? Eight. Where is the death certificate of?
My lord, I have annexed.
Annexure B.
Annexure B. Page 15, my. Of my happy.
Dhirendra was the administrator.
Yes.
Dhirendranath Ganguly was the administrator.
No, Dhirendranath Ganguly is the father of Samal Kumar Mukherjee. He
Where
died.
is the death certificate of Samal Kumar Mukherjee?
Annexure B, my lord. Page 35. I'm sorry, my. Page 35 of my. Page 35.
So after his death, who is administrating this property?
Page 35 will always got it. Death certificate of Samal Kumar Mukherjee. Annexure B.
This is an application for recording the death of Samal Kumar Mukherjee. And for incorporation of the name of the applicants in his place. Learned registrar in insolvency is directed to furnish a report. It is found that it is found that the letters of administration granted on
Administration was granted my lord.
2008.
Granted, my lord.
2008,
2008.
2008. And Amol Kumar Mukherjee expired on
Lord, he expired on 31st July 2009. Annexed B.
9 and today we are in 24. Why after so much delay you have filed this application?
He was in the out of space.
Who was out of space?
Service, my lord. Now it is necessary to, my lord, take steps and accordingly he has.
Who was out of service?
My lord, this, yeah.
31st July 2009.
Applicant, my lord.
Learned registrar in insolvency is directed to furnish report in respect of the prayers. Release this matter after on the returnable date. Release this matter of the 16th. ওইটা নিয়ে চেক করুন যে কোনো অন্য কোনো অ্যাপ্লিকেশনও ফাইল হয়েছে কিনা কোনো
Matter will appear, my lord, 16 December. I'm developing.
Item number 9.
Petitioner, my lord. That matter, my lord, Everest apartment matter, my lord. Where my lord has passed an order, my lord, for to appoint a special referee to execute a deed of conveyance, my lord. In respect of a flat, my lord, I am an agreement holder. Several applications were filed, my lord. And my lord, in my lord equalates, there are certain errors in the order dated, wherein the special officer was appointed. Such that order was corrected by an order subsequent order, my lord. Now, for that purpose also, the deed couldn't be executed, and one more issues was there, my lord. The applicants are resident of Hong Kong, my lord. So there are some issues regarding KYC that needs to be sorted out, my lord. For that purpose, my lord, some more time.
Where is the special officer?
I'm told that he'll be appearing online, my lord. Mr. Meghajit Mukherjee is the special officer, my lord. My lord, his order dated 2nd of September.
When can this be completed?
My lord, this will take some time, so I will be praying for 2 months' time.
On the prayer of learned advocate for the applicant, when?
2 months' time, my lord, because the applicants are.
Release this matter in the monthly list of March 2025.
Grateful to your lord.
Item number 12.
A similar matter, my lord. Here, my lord was please pass an order. It's regarding the Everest House building, my lord. On last occasion, my lord was pleased to pass an order.
See.
My lord, 10 and 11 separate application. Different application.
10 is. This is 10. 102.
Item number 10.
Because item 10, I'm for the defendant number. 10 and 11 is different from item number 9. It's not connected.
10 you make your submission.
My lord, in item number 10, on last occasion, my lord was pleased to pass an order in terms of prayer C, my lord. Accordingly, we had made the paper publication, my lord. My lord, here is my affidavit of compliance.
Yes.
Hello, now I'm praying for prayer B and D. I got a similar kind of order appears in page number 122, passed in a different application.
Okay. আসুন। This is an application for execution of deed of conveyance. Affidavit of compliance filed by the applicant is taken on record. This is an application for execution of deed of conveyance in relation to flat number 4 capital B and 1 pantry and toilet situated on the 4th floor of Everest building at 46C Jawaharlal Nehru Road, Kolkata 700071 in favor of applicant's nominee Sarita Jain.
Total is 103, man. I apologize, my lord. I apologize.
Para. Pursuant to order of this court, dated 1st October 2024, publication in English and Bengali daily has been made by the petitioner. Accordingly, let there be order in terms of prayer B and D of the notice of motion. Mr. অন্যান্য রীতি কাকে দেবো এটা এক্সিকিউট করার জন্য সেগুলোকে দিয়ে দিল কাকে দেবো একজন অ্যাডভোকেট এই করে সেনগুপ্ত করবে সেনগুপ্ত পেছনে যে বসে আছে কি নাম বলুন তো সৌরভ Mr. Sengupta, you will take the pen in execution of the deed. Who is a junior, any junior or Mr. Saurav Sengupta, learned advocate. Bar Association, Incorporate Law Society, member of Incorporate Law Society, is requested to direct is appointed as special officer to execute direct is appointed as special officer to execute and register necessary deed of conveyance on behalf of Western Building Corporation. Yes.
One humble submission. So deed of conveyance, my lord, the applicant is willing to gift it to his wife. My lord, it will be a deed of transfer or deed of gift.
Deed of gift. You are molding your prayer, no? What is your prayer then? Deed bole diye, okay? Deed of transfer kar de.
Deed of transfer.
On behalf of Western Building Corporation. The remuneration of special officer is fixed at 1500 James. The learned special officer shall submit a report after completion of registration of deed of conveyance on the returnable date. How long it will take?
1 month.
1 month. Please this matter. January মাসের date বলুন 10th of January. Monthly list হলে হবে না কেন?
Kindly fix a date.
বা 17 January করে দিন 17 January preferable সময় পাবে 17 January. Thank you.
My lord, item number 11 is also similar matter, my lord.
Similar.
I'd like to file my affidavit of complaint.
বাড়িয়ে দেবো 2000 করে দিন 2000 করে দিন
Item number 11.
তাহলে ওটার একটাই করে দিন না উনি থাকলে হয়ে যাবে সৌরভ বাবুকেই করে দিন এটাতে একই অর্ডার দেখি তাহলে this also do.
Office number is different.
ওই নাম্বারটা দেখে নিয়ে করে দেবেন। অ্যাফিডেভিট অফ কমপ্লায়েন্স গিজার করে নিয়ে সৌরভ সেনগুপ্ত ওনাকেই করে দিন। In both the matters, you are appointed. Oh.
Much of.
Item number 12.
I think we have got the applicant of ITP number 10 of the.
Kolkata Municipal Corporation.
In this matter, you
What happened?
Remember, in this matter, your lordship was pleased to appoint a special officer to take efforts to sell a property at Bovazar, and the learned special officer has held a meeting to conduct a sale of that property.
A couple of meetings which were held. One of the issue which arises is in terms of my lord's order, I am to make out a public notice, have a public notice issued and thereafter invite bids for the purpose of the sale. But I believe, my lord, the applicants, they are of the intention that the public notice is to be limited to the only for submission of bids by the respective parties, but none of the other parties are or co-sharers are before my lord. So, my lord, there seems to be a interpretation of the order is where it has been stuck. Also, given a format for the sale notice that is to be published. I have also circulated that by way of a of an email.
What is prayer B and C of the notice of motion?
It's to make public advertisement.
Prayer B is the learned special officer be directed to make public advertisement in daily newspaper having wide circulation, inviting offers for sale of the property situated at the property so and so on as is where is basis. The learned C is the learned special officer is directed to negotiate with offerers for the sale of this said property. My lord, here is the point where the issue is whether the offerers would be persons in the public domain or the co-sharers. This is where the applicant has.
That's valid. It should be the co-sharers. Co-sharers should be given a chance to give their bids, give their offers. If the ability to purchase the property, then they will pay the price and get the property. If they are unable, then it will be put in the public. Versus this is an ancestral house. They should try to get the property.
None of the deeds in respect of the property is available. The other properties have already been disposed of.
How the other properties were disposed of?
Among the parties.
Other parties.
Among
And
the
none of the defendants or plaintiffs in that suit are present before this court, save and except only the applicant. So, my lord, it may be an impediment. It may be difficult for me to reach out to the co-sharers because none of them are appearing. Otherwise, I will have to send them separate.
Then give a notice to them. Give a notice to the co-sharers. Have you given that? No, you have made a paper publication. Give a notice to the co-sharers.
If my lord takes up the cost title.
What is the valuation of the property?
No, my lord, valuation of the property, the advocate had indicated that he'll supply, that has not been supplied yet, but that can be taken from the government, the registry.
Registrar, I'm giving a direction to the registrar to cause valuation of the property. And in the meantime, you cause notice to the co-sharers.
The issue, my lord, only where I'm facing the problem is from the cost title, my lord, I'm getting all the defendants are indicated to be residing at 19 Siddheshwar Chandra Lane. But my lord, there is no one residing in that property, 7 except 4C, which I have, from my inspection, I have come to learn that they have been the only persons who have been residing for the last 40 years. All other co-sharers have moved out.
Other co-sharers' address are different, sir.
My lord will kindly take up 1, 2, 3, 4A, B, my lord 5, 6, 7. All of them are for 19 Siddheshwar Chandra Lane, my lord, Bovazar.
But 7 except 4C, none of them are residing there.
If
Who are the co-sharers? One. Second.
may I give one proposal, my lord, that first the receiver give a notice to all the co-sharers. Whatever address is there in the cost title, let them give a notice to all the co-sharers that this property is being put for sale. If you all are interested, any of you are interested to retain this property or get the property, then you can give an offer. If any offer comes up among the co-share, well and fine, my lord can consider it. If not, my lord can put it to property in public auction.
So in that event, at first, the valuation of the property should be there.
That my
Because
advocate on record.
while giving a notice, he has to indicate this is the
reserve price.
base price. Yes.
That my advocate on record can apply and get a assessment done and give it to the
By-
give it to the learned receiver. By tomorrow he will give it. Apply for it. Give the price to him. That my able. Put it there.
Not that by that way. Let the registrar make the valuation through a valuer, get the valuation of the property. Thereafter, he will send a notice.
That would be only the
Sure.
cost part is there. That is the only part. That will incur some cost if the valuation is done by some valuer.
So some cost has to be incurred. Otherwise, how can he put the value? He cannot make it out of his own way.
No. The registry office, there's a online system to make a valuation, get a
No,
valuation of the
not that valuation. He will inspect the property. The valuer will inspect the property and then fix a value.
Give a price.
Give your report. Mr. Ratul Das Learned. Special officer submits that pursuant to order of this court, publication for sale of the property has been made.
I have
How-
circulated a draft, but it has not been made. The publication is not made because, my lord, one, the certified copies were not available, which is why the reserve and the valuation was not available, which is why the reserve price
Submits that since the valuation and the certified copies of
the deed
of the deed of the property was not available, he could not make publication for sale of the property. In view of the above, learned registrar original site is directed to appoint a registered valuer for causing valuation of the property comprised within premises number 19 Siddheshwar Chandra Lane, Kolkata 700012 and file a report appending such valuation report on the returnable date. January 1st week. First week of January. It a date दिन होता valuation report का cover for the necessary in January. Let the valuation report come. In the meantime, do not make any publication. After the valuation report comes, he can issue letters to the co-sharers. You press your prayer on that day after the valuation is received.
Absolutely. Everything should done.
बारह तेरह तो एक ही 12 and 13 same.
Item number 14.
14.
For sale of a property, my lord, in a partition suit, where the property has been attached. As a matter of fact, my learned friend's client has been directed to put in an amount. If they don't put that amount in, then my lord,
Public auction.
Auction. The application for the auction, your lordship, on the 25th of September has passed an order. 20th of September, your lordship has passed an order directing filing of affidavits. We are here, your lordship, on the 2nd of December, my lord, you are supposed to file around the 9th of November.
Let's
They are
touch
wanting some
ONV.
time, I believe.
Oh, It is that matter in which they were supposed to deposit a sum of rupees 60 lakhs. Oh, yes. Yes, sir.
বলুন।
The defendant number one. And if it's in respect of company number 12 of 2020, the evidence submission has been prepared, but due to the illness of defendant number one,
When it will be filed? By Friday?
and the copy has
Copy been given to Mr. Ray?
No, not as yet.
On Friday, I'm fixing it.
কপি কবের মধ্যে দেবে জিজ্ঞেস করছি।
Okay. Mr. D.C. Thakur, learned advocate appearing for defendant number 16, extension of time to file affidavit in opposition within the course of this week. Let such affidavit in opposition be filed by defendant number 1 within Friday. What is Friday?
Friday is the 6th,
6th of December. Advance copy of such affidavit in opposition be filed, be served upon learned advocate for the plaintiff applicant. Reply by? A reply, if any, be filed by 12th of December. Release this matter. Anjan Babu. 16th December.
17th, but only 16th.
17th.
17th. But only one thing, Malad, let this be peremptory. If not, Malad, I'll mention. If they don't file the opposition, Malad, I'll mention for listing, Malad. For them. যদি ফাইল না করেন মেনশন করবো। Very grateful.
I don't know, 15.
My lord, I was appearing for the petitioner, my lord. My application for revocation of a grant of probate. On the last occasion, my lord, I had served upon the respondents, but on last occasion also, and my lord, on this occasion itself, my lord, they are not appearing. So, my lord, I was just suggesting, my lord, if I could serve upon them once again and my lord come back.
Okay, affidavit. Who was the learned advocate representing the petitioner?
My lord, this was my lord, seeking for revocation of a grant made in 1995.
85.
1995, my lord.
Delivered. Who was the learned advocate who appeared for the applicants?
At the point of time,
Urshi Bhattacharya. Okay. It was probate or letters of administration?
my lord, probate, my lord. Probate of a purported will, my lord, of 1991.
What is the ground? What is the ground?
Ground, my lord, as pleaded would be, my lord, on 3 or 4 grounds, my lord. It would be the divergence in the signature of the, my lord, propounder. Then, my lord, not issuance of, my lord, citation upon the actual legal airs. And, my lord, apart from that, we have also pleaded, my lord, the lack of intention, my lord, to execute such will.
The applicant is the daughter.
No, my lord, the applicant is not the daughter, my lord. If my lord could come to page number 83, my lord, I have annexed a family tree over there. He is the, my lord, son of the grandson of the deceased. And my lord, the other grandsons and granddaughters.
What is his name? His name is?
So the deceased name would be Gomti Shetani Chamaria.
And the applicant herein?
Applicant is, my lord, she is the son of the third wing. Vimal Dhandani, Amit Dhandani is the applicant. And my lord, the respondents, my lord, are the other grandsons and granddaughters of the deceased. And my lord, whoever are alive today. Where is the abstract?
Service has been affected on all the.
Service have been affected on all the respondents, my lord. My lord, is the affidavit of service from page 6 onwards, my lord. There are 6 respondents, and upon 6 from them it has been served.
Okay. Yes. Yes, your argument, yes.
I shall serve it upon them 1 second.
Not
My lord,
required.
says that I serve it upon them 1 second.
Not required. Service is complete.
Service is complete otherwise, my lord. Then, my lord, is in my lord's pressure to start the hearing of the matter.
Yes.
My lord, then may I beseech, my lord, may it be taken up next week, my lord. I'm led by Mr. Ghosh, my lord, the senior counsel, my lord.
জানুয়ারিতে করো affidavit of service filed on behalf of the applicant is taken on record. This is an application for a revocation of
A revocation of a will dated October 5th, 1991.
revocation of the grant
Of the probate.
of probate
A grant of probate, my lord,
probate
made on February 27th, 1996.
dated. Once again the date.
My lord, probate dated February 27th, 1996.
on the prayer of learned advocate for the petitioner. List this matter. 17th.
Great.
Item number 16.
Registration application.
But they have not, my lord, served any copy as on date, my lord, on us. Let them, my lord, serve a copy on us. And let, after that, my lord, they may press the application.
Equal direction children.
File for the first time. It's happening for the first time.
The order dated January past government jurisdiction dismissing the suit. Dismiss for default. Yes, sir. This is an application for restoration of the suit. Mr. Saurabh Sengupta, learned advocate appearing for all the defendants.
Only
No, no. Appearing for the defendant seeks to file affidavit in opposition to the present application. Let such affidavit in opposition be filed within a period of 2 weeks. A reply thereto be filed within a week thereafter. This is matter after 3 weeks. Learned advocate for the petition is directed to serve. Advocate on record for the petition is directed to serve copy of this application upon learned advocate on record for the defendant. After 3 weeks.
please from the date of service.
ওটা করে দিন affidavit of January তে দিয়ে দিন. Is the copy with you right now? You're not carrying the copy?
There was a lot of history regarding this restoration, my lord. If your lordship remembers, my lord, there was an application made where, my lord, there were 2 orders. Your lordship released that matter. They went before Justice Rao for clarification, and there they considered, my lord, that they had annexed the wrong order. They took leave, my lord, to file afresh. This is that application. That's why, my lord, I'm seeking a copy. Otherwise, my lord,
Okay, I remember, yes. You have shown. Then I have to check the website whether that order has been approved. Yes, correct.
Absolutely.
Yes. From the 2 weeks from date of service of the copy. On a submission of Mr. Sengupta, the Bolodin, the copy of the application has not yet been served upon the learned advocate for the defendant. 2 weeks from date of service. Reply to 1 week thereafter. After 3 weeks.
Item number 17.
But this is that matter.
Come.
Your lordship, at the outset, I'm submitting that the learned advocate who is appearing on behalf of the receiver, party receiver. Your lordship, he's gotten a stroke in night, yesterday night, he's admitted in a hospital today morning. In view of the matter, your lordship, can you attend for?
Have you laid hands on any of the copies of the pleadings?
As fell from your lordship on the last occasion, we related to the erstwhile advocate on record, that there is no response from him. But we are in the meantime, my lord, Mr. Ghosh, my learned advocate on record, was called upon from the department, and my lord, it was told to him, informed to him, that a certified copy of the some of the documents, including the certified copy of the plaint, is lying with the department.
That's fine.
Connected with the
Okay.
But that is an unamended copy of the plaint without containing any of the amendments that have been carried out. But in the event a reconstruction of the records is made, but the subsequent amendments have to be incorporated in the plaint. That is all. And my lord, the suit can proceed.
First of all, let us first take one step.
Very.
If it is there, then a
informed that
reconstruction order can be passed. Any written intimation given by the registrar?
Called by one of the officers, and I have shown, they have shown me the paper, the document, and I've seen that in a annexure of an application, the plaint is there. I mean, the copy of the plaint is there.
Certified copy?
not the certified copy, it's an annexure to another application.
Okay.
That application is there, but the subject matter, the body of the state is there. And I've been told by the officer that
See,
we are legal. He will adequate.
you were given any notice, your defendant?
I have already told my learned advocate who is appearing for the receiver.
I have heard you.
Yes.
You are representing whom?
1A.
1A. Note for the state as per the previous decision, the undersigned department communicated the recovery plaint and whether the annexure could be taken into a substitution or matter. Verifying the document on an advocate said that an amendment was carried on the cost item of 1999, which has not been referenced in document. The paper would send to your lordship's court for presence in substitution of original plaint. Much. দেখি তোরা এ পাঠিয়েছে এটা You have inspected this document? Document. This was part of which application? Here is the report of cover. Only for a kilo. Here is the report of Lane Registrar Original Sign dated 30th November 2024. Para. It is found from the aforesaid report that a copy of the plaint copy of the plaint has been traced out as an annexure to one petition. This was annexure to which petition?
You could grant it to your petitioners to proceed with suit being titled suit number. Actually, the commission was sick for continuing with another suit regarding this. Is suit number, that is suit number 525 of.
কি বললাম?
A copy of the plaint has been traced out.
A copy of the plaint has been traced out, being annexure of a petition filed in CS 817 of 1937. Learned advocate on record for the plaintiff submits that he made inspection of the copy of the plaint on being called by the registrar original site. What is the petition of which this particular copy was annexure?
Leave was sought for from the honorable court.
Okay.
With a suit.
Okay, got it. You ready? Learned advocate for the defendant is granted liberty to cause inspection of the copy. Defendant number 1A. 1A. You go and inspect this document before the registrar. Whether what has been unearthed from the other documents, whether it is a copy of the plain. If you approve, if there is approval of both the sides, whether this can be considered as a plain for reconstruction.
Unattended suit. That was the 1937. But I have been informed by my client that in 1999, an amendment was caused. A substitution application was caused. Accordingly, the amendment of cause title has been done in 1999. But I haven't found that record. Not in the, not even in the suit rings.
Okay. You know?
For the defendant number 1A.
That would cause, yes. Mr. So-and-so learned advocate for the plaintiff indicates that the amendment of the original plaint, the copy does not have the amended portions, and therefore the amended plaint is also required. Next, learned registrar original side is directed to take appropriate steps for tracing the amended plaint entitled in CS number 817 of 1937. Only once there was an amendment, the report records 1999.
I haven't seen that application. There's a change.
Oh. Acha. Learned advocate for defendant number 1 informs the court that learned receiver has fallen sick.
Not receiver, my lord. The learned advocate representing.
Learned advocate representing the receiver. Mr.
D.S. Mallik, Durga Shankar Mallik.
D.S. Mallik has fallen sick.
And he's admitted in hospital, my lord, today in morning.
And has been admitted to the hospital. Is this matter after 3 weeks? What must the athletes even লেগে যাবো কি করছে ওকে ডিরেকশন দিয়ে furnish further report.
The only apprehension that the Shebaites are afraid of is the receiver is not keeping well. There is something.
Not receiver is keeping well. Advocate of the receiver.
Apart from the, I'm
not saying of advocate of the receiver. You are saying of.
Go and inspect that record whether this is a copy of the plaint is correct or not, and thereafter you inform the court. And in the meantime, direction has been given to search out trace out the amended plaint.
My leader, my lord, the advocate record is sick. He's admitted in hospital.
Not saying about him. The receiver himself is also.
Sir, I am submitting what you are submitting.
That is
Your lordship kindly give some more.
Next demo. এত গালাগালি করে একটা কপি পাওয়া গেছে কি আমরা বুঝতে পারবো না ওটার অ্যামেন্ডেডটা পাওয়া গেলে ভালো হয় রিকনস্ট্রাক্ট
Deeply.
18 tickets.
I have come to learn. Plaintiff has also died.
One of the plaintiff, my lord, on earlier occasion directed me to serve the notice upon the learned advocate on behalf of the plaintiff, but I couldn't find out their address. So I have served upon the plaintiff. One of the plaintiffs has accepted and I am placed.
Which plaintiff has died? This is an application for?
Has accepted the
This application is substitution.
This is the original claim from record.
May I please?
And this video be recorded. Okay. Name legally as mentioned in affidavit in support of master son is substituted by way of amendment. They have to carry out amendment, yes. When did they die? When did Amol Mollik die?
Whole died in 71.
My lord, Mollik has passed away. His legal representative have filed this application as the plaintiff did not take any action, although they were residing at the same house. And it was known to them because Amol Mollik died in the medical college and disputed property is the 155B Mahatma Gandhi Road, not so far. One of the plaintiff is still residing there, Sudev Mollik, and Joydev Mollik also there at that time. So how they have ignored that we are not aware about the date of the Amol Mollik. So as the plaintiff could not file or did not file this substitution application, the legal heirs of the Amarnath Mollik has filed this substitution application. And my lord, after the case of the Amarnath Mollik, his widow informed his lawyer about the death of the husband, and he expected as that he is not so acknowledged of the court procedure. She has thought that her lawyer has filed the substitution application. But Amula Mollik passed away on 4th February 2021. A few days before she came to know that her lawyer has passed away. And after death, that Amarnath Mollik's legal heirs, son and daughter came to know when they tried to file the Vokalatnama to engage new advocate that no substitution application has filed. And my lord, my respectable submission is this. This is the partition. All are the equally interested in the share of the property, and in this regard, I am placing on citation.
This is with regard to Amola. 71.
The court has inherent power to act the defendant or the plaintiff's heirs, as in the case of the partition. Order 1 rule 10.
Okay. Yes. You have filed your opposition.
Firstly, my lord, plaintiff number, defendant number 5 was substituted.
But I didn't get any copy. I have no knowledge that before my
Defendant number,
I don't know. It has problem.
defendant number 5 was substituted.
Subsequent applications were filed.
No copy of the order has
A subsequent applications were filed in this case, wherein the substituted defendant number 5's names appears, they have been served copies.
Oh.
So one of these applications were not identified. That's not so. Because they were dismissed. Case 3197 of 2018. Where I can find from the first title. Amula Mollik representing minors, Tapon Mollik and Interim Mollik has been substituted in the first title of the claim. 71 he died. It's impossible that the
Onion in it.
claim has to be before my lord.
This is an application for substitution of deceased depend number 5. Amor Kumar Mullik. Amarnath. Huh? Amarnath na Kumar. Amar Kumar Mullik and his widow. What is her name? Amola. Amola Mullik. Mr. So learned advocate appearing for defendant number 6C and 6D submits that Amor Kumar Mullik defendant number 5 expired in the year 1971 and his legal years were substituted in the suit. He submits that the cause papers pertaining to the suit is required to be gone into. In view copy aste paren, in view of next week again. No, it cause paper to ante cause in so 1968 is suit. No, it's 2 weeks for it. Release this matter after 2 weeks. Okay.
On to the petition service. Apply for it.
Yeah.
No. দুটো তো ওদের আসবে প্লেনটা অরিজিনাল প্লেনটা আসবে
Plaintiff is my application. I'm for the plaintiff. This is a suit for dissolution of a partnership firm and for partition of the assets. Your Lordship and the occasion consider the applications in the suit where there are joint special officers. Your Lordship passed the order for sale. And in this application, there's a subsisting interim order of injunction. So, we are enjoying that.
Where is the injunction?
My lord's order dated 2nd of August.
Yeah, next to the application.
No, in this application, the order was passed. 2nd August.
In 20? In GA 20?
In GA 20.
On you know.
The order guru then. 16th May, 2nd August.
It is actually on it. It is a Rajasthan property.
Yes. One of the properties in Rajasthan. সেখানে চলে গেল would your lordship kindly permit us to hand up our because in your lordship's file possibly this has gone with some other application. There are so many GAs, so the orders might have gone with some others.
Kalke aani nahi? Not today. Kalke.
But I was humbly beseeching that this application may stand over because the interim order is there. It's not a limited interim order. The other it may stand over till the other applications.
When are the other applications coming up?
16th May order আছে আর একটা আছে
What is the date fixed?
3 weeks from 13th November the applications are going to
On the prayer of learned advocate for the petitioner.
The other applications your lordship has been pleased to direct let the matters go out of the list with liberty to mention because your lordship has been pleased to direct the special officers to take steps for sale, make publications and mention as and when they are ready they're ready with the offers. So this may also because we already have the interim.
On the prayer of learned advocate for the petitioner, let the matter go out of list with liberty to mention. Let it be out of list for the time.
It's not limited, so I need not trouble your lordship. Great. Next.
Item number 21.
21, I am for the plaintiff, my lord. Only one predicament, my lord. They have filed a GA3 for rejection of the plaint, my lord. Before my learned friend starts, the pleadings on the GA3 is complete. My lord, the defendant number 2A, the substituted defendant number 2A has died. But I have taken out an application, but the predicament that is coming out, my lord, the department has given this defect. The date certificate says the name is Sushila Kumari Raidhani. And my lord, in the cost letter, it is written Sushila Raidhani. But I'm seeking leave from this honorable court that both the names that are appearing are same persons. Without that leave, my lord, the department is not letting me file this application. But this is the department that is given in the application.
You are representing whom?
And the plaintiff. But defendant number 2A, the substituted defendant, that has also died. The date certificate is already there, but the date certificate name says Sushila Kumari Raidhani, and in the cost letter it has gone down as Sushila Raidhani. And
Is
department
there
say-
any other document wherein the name appears to be Sushila Kumari?
Yes, my lord, the first annexure of the application that I have handed over. Second page will be the death certificate.
No, save and accept the death certificate. Is there any other document where her name has been recorded?
No, my lord.
Plaintiff, copy of the plaint?
Copy of the plaint, my lord, that amendment that has been done on plaint, amended plaint would show that it is Sushila Raidhani. Name has gone as Sushila Raidhani. This amendment was done in 2023. Take 2 of 2023 was the application for that amendment. From there it has happened Sushila Raidhani.
Why? Sushila Raidhani was there from the very beginning.
No, my lord.
After the death of defendant number 2, she has been substituted.
After the date of defendant number 2.
What is her name?
Tilakumai Radhani.
So nobody indicated?
Yes, that is the difficulty, my lord. When we have the death certificate, we came to know it is Sushila Kumari Raidhani. That is handed over by my learned friend on the last day. Kindly grant us leave that these are same persons, my lord, so that these two applications can appear together.
File an affidavit stating the facts that this has gone down. The person who has expired is Sushila Raidhani, Sushila Kumari Raidhani.
Only difficulty is the learned advocate on record who has already prepared the documents, my lord. He is in hospital, but probably will come in January, mid-January, my lord.
Cannot help it.
But if my lord grants leave to that effect that these two persons are same, my lord. But the death
Something
certificate was
has to
handed over
come on
by-
record. The
That is-
plaint records Sushila Raidhani.
But my lord, my learned friend is representing here. It is her mother. So there should not be any difficulty regarding the identity of the person.
Lordship, kindly see your order dated 5th November 2024.
5th November. Sushila Raidhani has expired. Yes.
Lordship, they had ample time to have come before this honorable court and file an application to that effect. Once the
On the
matter
last
is at
occasion-
preliminary hearing stage, they come up with
Yes,
this
my learned
particular alibi, the name, there's a problem with the name.
And on the last occasion, my learned friend has handed over me the death certificate. I came to know then.
Lordship had given 2 weeks time for them to amend the plaint. If
I
this
have
was
taken out the
particular,
application.
They could have taken leave of this honorable court and filed a fresh application thereafter.
He's not listening to me. I have taken out the application, but the learned advocate on record is already hospitalized. I cannot take any further steps. That is why the matter was delayed.
File the application then. After he
Okay.
joins, file the application.
Kindly grant me leave on the application itself. It will be filed immediately.
No deal. Stating the fact, either you file an affidavit or file a application stating that this mistake has gone down. Nothing will be on record.
But then it will take some time. Or the learned advocate on record is not present right now.
This should have been indicated at the time when substitution of division number 2 was made.
How will I know? It is not death certificate was not with me. We know that the name was Sushila Radhani. It was not indicated by the mandate friend who is appearing for the defendant. He is appearing for the substituted defendant. He
If
did
they
not
knew the
indicate.
names
Death
of all the legal
certificate
heirs,
produced on
only this
behalf of.
particular name they did not know.
He did not indicate.
What should I indicate? It's your work.
It's my work. See, how will I know?
You are carrying the application. It is a application.
But this is my application that is to be filed regarding the recording of the death.
What is this order? 21st September. It speaks that the report contains the death certificate produced on behalf of.
No, my lord, that is different.
That is of the defendant number 2.
Yes, different number 2.
Take this file, this application will see. Not now. The file করতে বলুন, দেখো।
Leave to the Mary is granting me leave.
No. Who is the recorded advocate on record?
Election book.
Let him come and file the application.
A kidney tumor operation, my lord, in mid-January.
In month of January, you take it up. Prepare this application and give a copy to the other side. Something has to be on record.
Lordship, let there be a time frame because this matter is pending since a very long time. It's a 1989 matter.
Very well. He is delaying by.
Or should I be delaying? I have been
He
substituted.
could
I've
not.
come with the
He
first
could not
case.
indicate that it is his mother's name is wrong. He could not indicate.
You have the death certificate.
On 5th November, it was handed over to us.
Please don't argue.
now
Please
we
don't
are-
argue amongst yourselves.
Week's time was given. They did not take any steps.
Mr. Pencil advocate for the petitioner. No, 3 3 is their application. No? 3
is there.
For the plaintiff. You are for plaintiff.
I'm for the
Plaintiff submits that. Take our application. You have also, Mr. Raidani has also did not indicate.
That is what I am saying, my lord. He did not indicate that his mother's name is
In
wrong.
your application is also it is Sushila Raidani. Sushila Raidani.
He has also typed his mother's name wrong.
How could I change the cause title?
How could he change? He could not indicate.
File an application. You will for the plaintiff submits that the name of defendant number 2 would be Sushila Kumari Raidani. 2A instead of Sushila Raidani. He seeks to take appropriate steps. Cumbersome है यार. What is the prayer made in the application which you intend to file?
Recording the death of the defendant number 2. Only that much, because no one is getting to be substituted. All the substituted has are already present.
File that application. In that application, I will indicate that this is the. That will be
service a copy of
that
that
will be
application.
sufficient.
Officially, we will serve it.
चलो কি বললাম Raidani. From the death certificate, the said fact could be gathered by the plaintiff. Seeks for accommodation since the advocate on record for the plaintiff is unable to attend the court due to illness. January 3. He will be joining on which date?
January, reopening of the January. While skipping this matter, the monthly list.
Monthly list of January.
Lordship, GA3 of 2025, I'm filing my affidavit in reply.
Affidavit in reply given copy?
Yes, copy has
Yes.
Affidavit in reply filed by the applicant is taken on record. Copy the other way.
Grateful Lordship.
Next.
Item number 22.
It's granting me leave. Or is granting me leave to file this application. From the order we will share.
Let him come, the advocate on record, file this application. What I say is, when at the time of taking up this application, I will record that.
But it is not letting me file it. I shall take my chance through the order that has been recorded.
This is my application. It may roughly come back to my lord. Once in this suit, I had made a prayer for release of this suit from your lordship's list.
Yes.
So that it can be tagged on to a commercial where similar prayers are involved. It was opposed by my learned friend, saying that there was no application to that effect. It was observed by my lord that we should take out an application. This is the formal application which we have taken out. Well, the facts are very simple and in fact need not necessarily be gone into in detail at this stage. Suffice to tell your lordship, my lord, it concerns a property on Shakespeare Shoroni in the entire 5th floor, in respect of which, my lord, I am a monthly tenant under the defendant. Put it in the year 2000, I filed this suit for framing of a scheme of maintenance of the common areas, as also for a declaration that I am a monthly tenant under the defendant in respect of the suit property. That prayer is specifically there in prayer B. Declaration that I am a monthly tenant in respect of the suit property. Well, I say that I am governed by the West Bengal Premises Tenancy Act. Shall go into that at the time of hearing of the suit. Your lordship may not be troubled with that at this stage unless a big issue is made out of it. In the year 2011, the defendant filed a suit for my eviction. It was a commercial suit. So now there are two suits. One is a commercial suit where they have asked for my eviction, and one is my suit where I have asked for a scheme of maintenance of the common areas plus a declaration that I'm a monthly tenant. So a declaration or adjudication about my identity qua tenant is an issue in both the suits. But it so happened, my lord, that this question that both the suits should be heard together came up before prior benches taking up these matters. And there are some orders to that effect. Without troubling your lordship further about these facts, kindly straightaway come to page 66. This is an order passed in their suit. This is a suit number CS 189 of 2011. My lord has page 66. The following issues are framed by this court. Whether the subject monthly tenancy, monthly lease was governed by the Transfer Property Act, whether the defendant came within the purview of the West Bengal Premises Tenancy Act and was entitled to its protection. So this is an issue in his suit, whether I'm a tenant or not under the West Bengal Premises Tenancy Act. Whether the monthly lease tenancy of the defendant was validly terminated by the notice dated 16th May 2011 issued by the plaintiff under Section 106 of the Transfer Property Act. Whether the defendant is liable to quit, vacate, and deliver a vacant and peaceful possession of the suit premises on the expiry of 15 days from the date of receipt of the said notice. Whether the amount of so-and-so paid by the defendant to the plaintiff as service charge was part of the rent. Whether the plaintiff is entitled to mean profit, whether the plaintiff is entitled to any other relief. So my lord sees amongst the issues framed in his suit, my position or my identity as a tenant under him is an issue. And may I just read out the rest of the order? This suit is to appear as the first suit on 18 July 2016. The plaintiff will file their evidence on affidavit of the first witness they wish to tender and circulate a copy to the defendant by 16 July 2016. The witness must be present in court to present himself for cross-examination after the affidavit is perused by the court and documents marked tendered for identification upon hearing the defendant. Certified, photocopy. So in their suit, these were the issues framed. This is of importance, as your lordship will subsequently see. Kindly come to page 68. This is also in their suit, CS 189 of 2011. By consent of the parties, the evidence in this suit and examination in chief will be in the form of evidence on affidavit. The evidence and affidavit of Mr. Virod Rampuria, one of the directors of the plaintiff, filed in court today, is taken on record. Let this suit once again appear as to be mentioned on 1st August 2016 to ascertain the assignment position of a connected suit, CS 273 of 2000, that is my suit. So a competent court of law, a coordinate bench, if I may say so with the deepest of respect, said, let this suit appear once again to consider the assignment positions. From that stage itself, the assignment was playing in the minds of the parties and the court. Kindly turn the page, come to page 69. Again, in the 2011 suit, time for the defendant in suit number so-and-so to file their written statement is peremptorily exempted till 16th August 2016. So they had not filed written statement in my suit. The parties in both the suits will be entitled to discover documents or additional documents by 22nd August 2016, inspection forthwith. The respective judge's brief of documents should be prepared by 29th August 2016. List both the suits for trial on 31st August 2016 fairly at the top. So a recognition that both the suits should be heard together. Issues already framed are hereby cancelled. The issues which I showed to your lordship are cancelled because their written statement in my suit is not ready. Fresh issues will be framed after discovery and inspection. The evidence and affidavit filed on behalf of the plaintiff in CS number 118 of 2011 is allowed to be withdrawn with the liberty to file a fresh affidavit as and when the occasion. So your lordship sees clear intention of the court is both the suits should be heard. Issues can be framed only after they have filed their written statement in my suit. Evidence and affidavit withdrawn. Both suits appear fairly at the top on 31st August 2016. Kindly turn the page. Well, in the affidavit in reply, well, may I file the reply, my lord? It has been served on the other side. অর্ডারটা কোথায় গেল? সঞ্জীবের অর্ডারটা? Yes. My lord, in the opposition, kindly take the opposition first, my lord. Kindly take the opposition. Kindly come to page 36. An order passed in my suit. Page 36. Though the two suits of which analogous hearing is sought pertain to the same property, the landlord does not agree that the two suits should be heard together. It is a question of they saying that we don't want the suits to be heard together. Whereas your lordship has seen, prayers are the same. There is identity of prayers so far as the two suits are concerned. There are observations by my Lord Justice Mukherjee that the two suits should be heard analogously. In a sense, the landlord may be justified, may. Since the landlord suit is ready to be taken up on July 18, 2016, and the landlord perceives this application to be an attempt to derail the landlord's suit. GA number so-and-so is disposed of without any order. Now, my lord, the next part of the sentence is very important. But it will be open to the plaintiff in this suit, that is my suit, to seek an assignment of this suit before the same bench where the landlord's suit is due to be taken. So I was given that liberty. Today, an impression is sought to be given as if, my lord, the first part of the order is operating as res judicata. It has been decided that you cannot hear. hear both the suits together. Specific liberty has been given to me to pray for an assignment. And this, coupled with the observation of my Lord Justice Mukherjee, that both the suits should be heard analogously, both the suits should be taken up together. And considering, my Lord, the commonality of issues, namely, declaration that I am a defendant in my suit, that I am a tenant under him in my suit, and a suit for eviction in his suit, in my very humble and respectful submission, my Lord, there is no reason, and I say this with the deepest of respect, Your Lordship, and also, my Lord, to the submissions that may be made by my learned friend, why a simple question, simple prayer for my Lord release should not be allowed. In this background, my Lord, I tell Your Lordship, when we made this prayer, initially wrote to the learned registrar. The learned registrar said, on perusing all the orders, that considering the fact that the suit is pending before Your Lordship, we should make the prayer before Your Lordship, and depending on how Your Lordship sees the matter, assignment can be made. The commercial suit has been appearing before another court, my Lord, in fact, just next door to Your Lordship. When we made the same prayer, my Lord has been pleased to adjourn the matter, my Lord, the commercial suit. More so when we told him that we have already made an application, and depending on that application, both the suits will be taken up together. Your Lordship is familiar with the concept of committee of courts. Today, my Lord, if these two suits, when one, where I have prayed for a declaration that I am a tenant under him, and two, his suit where he asks for my eviction, if two different courts come to, my Lord, two different conclusions, there would be chaos. There is no denying the fact that the issues are overlapping. There is no denying the fact that they may be dealt with separately, together. In his suit, he has filed an application under Chapter 13A. We will deal with that application when it comes to it. But unless, and I say, this application is not meant for the purpose of showing any disrespect to Your Lordship in any way. It is for convenience, and the convenience which is permitted to be taken advantage of and taken care of by two other courts. In this background, my Lord, I respectfully submit that it's a fit case where the suit should be released so that, my Lord, we can apply for assignment, and it may be assigned before the court where my learned friend's commercial suit is pending, so that both may be taken up. For the time being, these are my submissions. And my learned Dunia, as rightly points out, my Lord, if the order for release is not passed, the orders of Justice Mukherjee and Justice Banerjee would be rendered totally, my Lord, obtuse. Those orders have not been challenged. There is no appeal from those orders. Those orders have not been passed in vain. And there is purpose. It's not as if I made a facetious or a frivolous application. It is made with a very definitive objective of seeing that the disputes by and between the parties, my Lord, come to an objective end. That is why I respectfully submit, to use a very common term, my Lord, heavens will not fall if the matter will release, because it's not as if it's being taken away from Your Lordship for any ulterior motive. It is so that both the suits can be heard together, which has already been held by a court.
Calcutta হবে দিয়ে
Only Miller, difficulty faster.
কালকে প্রথমেই থাকবে এটা
Let it appear at the top, my Lord. So that
ফার্স্ট আইটেম
very,
উইটনেসের পরে থাকবে আফটার দি উইটনেস অ্যাকশন অ্যাক্টিভ
very grateful to my Lord.
Congratulations to Mr. Thoughtful.
Prefer an appeal from